मैं item number 31, madam.
31.
31. Sir, we are filing an reply, FID reply, my lord. It may come up on 7th, my lord. We have mentioned. Because interim order it will consider. Interim order it will consider, my lord. We are filing an reply.
You don't have to file. We can take it up. Where's the question of filing reply? We can take it up now.
My lord,
We can take it up. There's no requirement of filing a reply.
my lord, some allegations are there, my lord. So
There's no, you see, I have, you see, the thing is that we can take it up. There's
lord,
no,
today-
there's no requirement.
today,
There's no requirement.
today I
You see, the problem, huh?
today also, my lord, I because we are filing reply, so I am not, my lord, ready, my lord.
When are you filing reply?
Within 2 days.
Okay, right.
It may come up on 7th, my lord.
No, next week. No, we'll, you see, I've read it. Basically, it's quite technical, the issues. Plus, there's an alternative remedy already availed of by the implementing agency, by that inspecting authority. There's an alternative remedy available, that appellate authority is there. So, one, that issue will be taken up there, then this issue, already an alternative remedy. Why don't you avail of that?
No, my lord,
And these
my
are,
lord,
these are
I have grounds, my lord. Nowadays, my lord, Supreme Court has said, my lord, that a hearing is to be given.
but there, no, but there are technical issues here, no?
My lord, everything I can place, my lord. That is why, my lord, I shall file the reply, my lord. That will come after Diwali, my lord.
By Diwali, you said you're going to file it within 2 days.
2-3 days, my lord, because it's collecting from that.
Yes. Who is for the other side?
I take consent from the, my lord, and
Right. Mr. G.N. Sahewala, learned senior counsel, submits that he will be filing affidavit in reply within 2 days and accordingly prays for adjournment. Full stop. The issue is with regard to whether the construction work was of substandard quality. And the submissions and the averments made in the affidavits show that there are technical issues which need to be decided. It is also the stand of the respondents that there is an alternative remedy available by way of filing an appeal, which has already been availed of by the inspecting authority. As such, the respondent's case is that the appellant should, the petitioner should also avail of the alternative remedy available. Full stop. On the prayer of the petitioner's counsel, who is granted 2 days time to file the affidavit in reply, list the matter on when?
7th of my lord.
Which one? A lot of fifth.
Wait, Your Lordship. I beg to mention item number 7, 8, and 9. This matter, Your Lordship, may not like to take up. There's an order of Your Lordship. But I'm for the petitioner. I'm for the respondent in this matter.
Okay, right. This item 7 and 9. This matter before some other bench, not before this bench.
Obliged.
Obliged.
When do you want it listed?
Your Lordship. I'm for the respondent.
This matter before some other bench and not before this bench in the next week. In the next week.
Obliged.
May I please, Your Lordship? I beg to mention for listing of a writ petition, Lordship, for withdrawal.
Okay. Tomorrow.
Lordship, in item number 13, we have filed a reply, Your Lordship. That may be kindly be called for.
Okay.
Thank you.
Lordship, I beg to mention item 2 on behalf of B. Lordship.
Item?
2, Lordship.
Yes.
He seeks some time for preparation. Matter may be fixed this Tuesday, Lordship, for final disposal.
Who's for the petitioner?
Mr. G. Sahib.
Okay, right. Mr. Ayab Thakur. Prays that the matter may be listed on Tuesday as he is not prepared today. Is it? Gustav? The issue is whether limestone is a forest product. This is the matter on sales.
Okay. My lord, I mentioned one item will list it on my lord Monday next, 28, my lord.
What is this?
Gesia payment, my lord. It was last listed on my lord 20 December 2022, my lord.
Okay.
My pleasure, Lord. I'd like to mention for listing, my lord, on 30 this month.
Okay. Huh? No, 30, no, not 30. After fourth, after third or fourth. Fifth.
Wait, please, Lordship, I break for listing of a urgent matter, motion matter, my lord. We had filed it today, my lord. But this is a tender matter. My lord, because of the stringent clause, my lord, we could not participate even. My lord, that is, the date of evaluation is on Monday, my lord. That is on 20.
So tomorrow,
I'm grateful, my lord. Highly appreciate.
have you given the copy to the other side?
Yes, my lord. Copy we have already served. Filing number we have just obtained. I'm grateful.
May please, Your Lordship. I'd like to mention item number 22, Your Lordship. This case was yesterday mentioned for withdrawal, Your Lordship, but it is come in the motion.
Huh?
Yesterday it was mentioned, this case was mentioned for withdrawal, but it has come on the motion.
It doesn't matter. You withdraw it. It's okay.
Yes,
You want to withdraw it?
Yes, sir.
Okay, right. Mr.
R.A. Law Court.
R.A. Lakhar, learned counsel for the petitioner, submits that he has been given instructions to withdraw the writ petition. Who is for the other side? SCPHE. SCPHE. Mr. Ayaba Thakur appears for the PHE. The prayer of the petition's counsel is allowed. Writ petition dismissed as withdrawn. Item 22, correct?
May I plead your lordship, with the consent of the other side, I'd like to mention item number 6. In this matter, we were supposed to file affidavit in reply, and our reply is also ready for affirmation, but our client conveyed that he is not well to come for swearing of the affidavit. And also my senior, Mr. R.P. Sharma, sir, also has a medical appointment, so the matter may pass over for the day.
Where is the affidavit in a position? I have not seen it. Just look at it, item 6. It's regarding that IMFL,
Yes.
IMFL, retail offshore. There is no affidavit in a position. That's what I did not find it. It's
Lordship, we have received that.
you have received.
Yes.
Who is for the other side?
I'm for the other side, Lordship.
You when did you file?
28, my lord.
28.
2008. It's not here in the records. So what is the filing number? No filing number. How come? No filing number. Okay. But you please check up with the registry. Miss
A Deca.
A. Dekha, learned counsel for the petitioner, prays for how much time?
On next week, 2 weeks.
To file a reply, madam. You want to file, you're going to file reply or not?
Yes, Lordship,
How much time?
2 weeks.
Prays for 2 weeks time to file reply to the affidavit in opposition filed by the respondent number 6. Full stop. And the copy of the, no, the affidavit of the respondent number 6 is not in the records. Though Mr. M. Chetia, learned counsel for the respondent number 6 submits that affidavit has been filed on, in, or on what?
On 28.
On 20, as filed on 28
20.
to 20 August 2024. Mr. M. Chetia shall inquire with the registry as to why the affidavit has not been put in the records. The registry should also look into the said aspect. List the matter after 2 weeks.
Highly
Okay. Supplementary motion item 23.
Yes.
Yes. May it please.
Is it maintainable?
My lord, with
I
utmost
doubt.
respect, let me point it out.
Huh?
Let me point it out, then your lordship will pass the.
Look, the thing is that you got a bill, you're not happy with the electricity bill. Pertaining to the year 2015.
Yes.
Now, you made a challenge to that in the consumer protection before the forum, district forum. The district forum has dismissed your case. You,
On two grounds.
whatever be the ground, you dismiss. Now you go in appeal.
No, Malad, that's where the problem will arise. Malad, the consumer, if your lordship looks into the order of the consumer, district consumer court, your lordship will find that first they have said that I am not a consumer within the definition of the Consumer Act. So if I am not a consumer within the
But
Consumer
no,
Act-
leaving that aside, are you a consumer?
Malad,
What is your stand? I'm not
Yes.
asking you,
yes,
what is
Yes.
what is your stand?
Yes.
Are you a consumer?
Malad, for the time being, if you go by the definition, strict
No, no,
definition of
Mr.
the
Counsel.
Consumer Act,
Just tell me in black and white. What do you consider yourself to be? Do you consider yourself to be a consumer?
yes.
If you, that means
But-
you find your,
but-
that means you find
No,
the
No, but
district forum
my-
judgment
my-
wrong.
My perception of a consumer may not be in consonance with the act.
Correct.
Yes,
But
so if your lordship looks into the definition.
no,
of-
no, sorry,
your lordship
sorry.
Kindly bear with me.
I'm dismissing your case.
No, your lordship will hear me and dismiss it. I have no objection.
No, you tell me the reason.
Yes, I am.
You see, one thing I'll just tell you. Your case was dismissed because the district forum said that you are not a consumer.
Fine.
Now, if you agree with that, okay. But
Yes.
you do
Yes.
not agree with it.
No, I am only aggrieved by the order of the district consumer to the extent that once you say that you are not, that I am not a consumer and that's why you don't have the jurisdiction, then why decide the matter? You should have remanded the matter to the appropriate authority to to direct me to go there.
Sorry.
Well, that has not been done, my lord. And if your lordships will not prepare to hear me, then I cannot, my lord. I
Yes.
take my seat.
Yes.
Lordship, there is an alternative remedy, statutory alternative remedy under the act.
He can go in appeal.
And
Where
as
is
per-
that appeal provision? That's all.
Section 17.
Right. Heard Mr. B.D. Kowal, learned senior counsel for the petition. Also heard Mr. K.P. Pathak, learned counsel for the state respondent.
Lordship.
For the
of
APDCL.
APDCL. My learned friend will represent the paper.
The petitioner's case is that an electricity connection had been provided by the Assam Power Distribution Company Limited to the petitioner's premises located at village Jagun Gaon, Nahar Katia, Dibrugarh district since 28/3/2023. The connection was originally registered under the name of the petitioner's late grandfather, Kireshwar Andik, with consumer number 219-00050, 2464, and meter number AS707493. Following the passing away of the petitioner's grandfather on 27/8/2023, the electricity connection continued to remain in the name of the petitioner's father. However, the petitioner has been paying the bills to the APDCL. Full stop. The petitioner's further case is that the electricity connection falls under the commercial category. Full stop. Next para. On 10/9/2015, the petitioner received an electricity bill for the period from 2/8/2015 to 1/9/2015. Wherein, now amounting to rupees 52,627.22. Full stop. Being aggrieved with the said bill, the petitioner filed a consumer complaint by CC case number 01/2016 before the District Consumer Disputes Redressal Commission, Dibrugarh, under Section 12 of the Consumer Protection Act 1986. To start. The complaint was dismissed by the District Consumer Commission, by the District Commission, by the District Commission on 1/2/2024. By holding that the petitioner did not qualify as a consumer under the Consumer Protection Act 1986. However, despite the said finding, the District Commission proceeded to consider the merits of the case and dismiss the complaint based on the findings on merits. Accordingly, the petitioner has prayed for setting aside the impugned judgment dated 1/2/2024 passed by the learned District Consumer Disputes Redressal Commission, Dibrugarh, in CC case number 1/2016. He's not challenging that order on the ground that he is a consumer.
Yes, Your Lordship. If he is aggrieved by the bill, even
By the
otherwise,
bill.
for that also there is an alternative remedy.
Yes. So let him go there.
Yes, Your Lordship.
You avail of the alternative remedy.
Problem is that, my lord, I would have placed the judgment of the Supreme Court. Showing that was my submission, that the consumer court, if it doesn't have the jurisdiction, they should refer me this matter to this authority. Your
So we'll
Lordship,
refer you, we'll
Yes.
set aside that order.
Just a
Huh.
because problem is that after I make my submission, your lordship will pass any order, will never object. But at least I should be heard to the minimum points which I want to place before you. Your lordship may not agree. The consumer court's order, I'm only.
No, you see,
I go
no,
before
no,
the-
just a minute before you. Sir. You see, the reason why this court was planning to dispose of was because at the initial stage, I asked you straight away, is it your case that you are still a consumer? You said yes.
No, I may say yes, but it is not in consonance with law because there is a judgment of the Supreme Court which says that the consumer court doesn't have the jurisdiction to say decide matters of electricity dispute. If they have a separate forum of consumer dispute redressal forum of the APDCL, and if it is dismissed by that authority, then it can go to the ombudsman, then to the High Court. But the consumer court, I was proposing to submit before this honorable court, because there are some judgment of the court which said that the consumer court should not go on such technicality and defeat the purpose of the very act by denying a person who is complaining of deficiency of service. There are two lines of way of thinking. But I am willing to go before that authority. But only what I was trying to impress upon your lordship was that in this case, my lord, the argument was heard on 6/1/2018, and the order of the judgment was passed on 2024 after 6 years. So I was till that time I go, your lordship will direct me to appear before that within 2 weeks. Till that time, my lord, they will not take coercive action because in terms of the subsequent proposal after the order of the consumer court, they gave the installment of.
No, but you make one thing clear. You have to make one statement clear before this court. Do you consider to be a consumer under the CPA Act? Under the CPA, you don't consider?
No.
So you abide by that part of the judgment.
Yes.
The next part of the judgment should go. That's all.
Yes, ma'am. And I'm willing to go before the other authority. But the only thing is what I'm trying to say is that my lord, the initial dispute was around 50,000 odd. I went to pay them the bill. They did not accept that until because there was an interim order of the District Consumer Forum not to take any course of action in terms of the disconnection notice and all. So thereafter, whenever I went to deposit the bill, they refused. No, you have to pay the surcharge. Now, up with the charge for that 52,000, now it has gone up to 2 lakhs and all. Out of the principal amount, I have paid all the amount except in terms of the settlement which they have given. Now only 1 lakh is remain. Now, whether they are entitled for the charges and all those things, we can argue before that. But for a limited period of 2 weeks, I will request your lordship that they will not take any coercive action, because if your lordship looks into the schedule at page 74, they have said that in the first schedule was 78,602, which was to be paid by 7th of October. I did not pay that disconnect. Then I had no other option because a person cannot live without electricity. This 7th October 2004, that immediately I paid that 78,602. Then the connection was restored. Now 24th October 24 today, they will again ask for 72,850. And if I don't pay, then they will again disconnect it. So I'm saying before your lordship that for a period of 2 weeks, we'll prepare the appeal, file it before the consumer redressal forum. Till such time, they will not take coercive action because the initial amount was 52,000. I will continue paying the current bill, which they are not willing to accept. And if your lordship looks into this tabulation of the calculation, my lord.
But you also, in the first instance, your grandfather died in 2003.
Yes, my lord.
It was your duty to inform the authorities that your grandfather has died and you are availing the electricity.
My lord, there
You are not-
there are also judgment. Ultimately, I have inherited that
Electricity
property.
connection.
But it is the APDCL's perspective in all these cases of the Supreme Court I have seen that it is the user ultimately who uses, he has to pay.
Correct.
Even if the person has died also,
correct.
it has, unless of course the property is sold, then some other parameters are applicable. Your lordship will kindly see this chart for a moment.
No. That's all. What else is there? No point wasting time.
Very well.
So
lordship.
I created for a limited period, your lordship will kindly protect this
So,
person.
so,
I had paid this page 74, your
so
lordship.
we'll set aside the judgment to the extent that it has decided the case on merit.
Yes, because that is beyond his jurisdiction.
Okay. Right. Whatever I said. That was the last. Insofar as the grievance of the petitioner has been decided on merits. First off. Mr. KP Pathak, the learned counsel for the APDCL, on the other hand, submits that, don't say on the other hand, submits, admits to the fact that if the district forum has come to a finding that the petitioner was not a consumer in terms of the Consumer Protection Act 1986, hereinafter referred to as the CPA, comma, the district forum should not have decided the case on merits. However, as there is a alternative remedy to challenge the electricity bill by way of regulation,
4.1.
4.1.
by
Regulation
way of regulation 4.1
4.1 at page 9981.
of the Assam Electricity Regulatory Commission bracket redressal of consumer grievances bracket regulations, comma 2002. Hereinafter referred to as the 2022 regulations, comma. The petitioner would have to approach the concerned Consumer Grievance Redressal Forum, bracket CGRF,
RF.
bracket close, under the 2022 regulations. I have considered the case of the I've considered the submissions made by the council for the parties. Full stop. This court is also, this court does not, this court is of the view that what this one thing you write, in the beginning, you also write, the counsel for the petitioner submits that the petitioner does not is not challenging the decision made by the district forum that the petitioner is not a consumer under the CPA.
Within the Consumer Protection Act,
Within the CPA,
1986 here.
Yes.
Yeah, because after 2019, it's a separate act. came.
1986, 1986. And then you come back. Where are we? Just before that.
Grievance redressal forum.
First stop.
Your lordship.
This
can you
court is
indicate
of the view.
address, my lord?
Huh?
Can you indicate the address? Others will run from room to room
What address?
looking for it. Where it is.
Okay.
It is at 6 mile, your lordship.
Okay, right. This court is of the view that when the district forum had come to a finding that the petitioner was not a consumer in terms of the CPA 1986, comma, it should not have gone into the issue on merits. As such, the impugned judgment, impugned that page,
65.
the impugned,
66
the impugned judgment
at page 65. And
dated 1/2/24 passed by the District Consumer Dispute Redressal Commission, Dibrugarh, in CC case number 1/2016. Is set aside, comma, only to the extent that the petitioner's complaint, only to the extent that the petitioner's complaint has been decided on merits and without disturbing the finding of the district forum that the petitioner is not a consumer under the CPA, 1986. Next part. The above being said, in view of the fact that there is a forum for redressal for consumer grievances under the 2022 regulations with regard to the electricity bills generated by the APDC. This court is of the view that the petitioner would have to avail of the alternative remedy available under regulation 4.1 of the 22 regulation. And accordingly, the petitioner is given the liberty to approach the CGRF under the 22 regulations, which is located at
He's located at 6 Mile.
6 Mile.
Guwahati, Your Lordship.
So located at 6 Mile, Guwahati. Full stop.
My lord, the consequential orders passed by the APDCL in terms of the consumer judgment should also now go because.
That, because it's not a consequence of the consumer forum. judgment.
No, they have
Because,
indicated that it's a consequence
no.
order of the consumer dispute redressal forum.
With that, let them take.
My lord, Your Lordship will protect me for a limited period and this period of limitation should not run because I was pursuing their remedy over
That
there.
to 14 will, section 14 will apply.
But when then Your Lordship, if you observe, then it will become easier because they are not judicial officers, my lord. It's a quasi judicial body, my lord. The limitation, who will explain to them, my lord?
You are there.
No, I'll not go to a to a consumer dispute order. That will be an insult to my gown.
So the fees are less, that's why. If the fees was 1 crore, you'll be running with 20 other juniors.
Well, those
Right.
clients don't come to me.
Huh?
Those clients don't come to
No,
me.
no, what I'm saying is that
Well,
it's not a question of courts. I think even the Supreme Court lawyers will go to district court.
Well,
They don't consider it below them to
Your
appear.
Lordship has seen my petitioners are all humble petitioners in the truest form of the term. My clients are not corporate clients. Well,
If they were,
I am not
supposing
fortunate.
if they were, then what would happen?
Being a first generation lawyer, I'm not fortunate enough that.
Anyway, leaving that aside, each to his own. So, the petitioner may approach the concerned CGRF.
We'll approach within a period of. 2
And
weeks.
the concerned authority within a period of 2 weeks from today. And the concerned authority shall consider the delay in approaching the said authority in terms of section 14 of the Limitation Act. Uh, Till then, no coercive action should be taken. No,
You'll not
no
disconnect me
coercive, no coercive action should be taken.
For disconnection.
Your Lordship will indicate that if he does not approach, then the.
No
consequences of-
coercive action should be taken by the authorities, by the APDCL. During the period of 2 weeks. That is being provided to the petitioner to approach the CGRF.
Thereafter, I'll pray for interim order before the.
That you do.
Your Lordship will indicate others, they will say that High Court has given protection you for 2 weeks.
Correct, then that's why,
Now, Your Lordship will give me
okay,
the. liberty.
to enable him to approach the concerned authority.
We are blessed.
State petitions accordingly disposed of. Item? Yes.
May please, Your Lord.
So the amount of 4 lakhs is clear.
That is,
The only thing is with regard to the interest.
yes, sir.
Now, I was just thinking about it. If, you see, there are 120 days, I think, is the issue.
Yes.
Correct?
Yes.
Now, it was your duty
Lordship.
to have an inquiry done.
Yes, sir.
and you did not do it.
Yes, sir.
So why should he suffer for it?
And Lordship, from 2019, perhaps as per the procedure laid down under the regulations of 19, he might be eligible for interest. The question is whether he would be eligible for interest from the date of the accident. That is what he's claiming.
Acha, acha. Date of,
So if,
date of accident 2011.
yes, that is what he's claiming.
It will come from the date of regulation.
I,
only.
in fact, got a Supreme Court judgment, but the Supreme
From the
Court
date of regulation. only.
From the-
Show,
prepared a short summary of the judgment. Sir.
no, just show them. I cannot
take
read
the
everything.
Lordship to the, because I've enclosed the entire thing, it's slightly voluminous.
From the date of regulation, how can you expect something from the date when no such provision is provided? Where is it?
Yes.
You don't have an extra copy.
I have.
Just give it to him in the meantime. He'll give it back to you.
No, he can keep it. I have another copy. Lordship, the judgment, your Lordship, it starts at page number 28.
28.
Yes, this is 2011-15 SCC 580. NTPC versus Maharashtra, Madhya Pradesh State Electricity Board and others. The issue before the Supreme Court, your Lordship, in those matters was that under the Electricity Act, your Lordship, tariff has to be determined by the Central Electricity Regulatory Commission. Now, section 62 of that of the Act says that if any party charges tariff in excess of the tariff determined by the Commission, then he is liable to refund it along with interest from the date of determination by the Commission. So these state electricity boards, your Lordship, filed a tariff case before the Regulatory Commission, before the Central Commission, against the NTPC, because NTPC is a generating company. So finally, the Central Commission held in their favor. The issue which the Central, one of the issues was whether for that period during which the proceedings were pending before the Central Commission, whether the interest is liable to be paid for that period. So the Central Commission said since there is no such provision in the Act, it rejected it. Then the matter went before the Appellate Tribunal for Electricity, the APTEL. The APTEL said, since there is no such provision in the Act, therefore you are not eligible for interest under the Act. But the APTEL used its powers of equity jurisdiction and gave restitutory interest to the
Who?
Appellate Tribunal for
Okay.
Electricity. It granted restitutory interest to the electricity boards, your Lordship. So the twin issues which arose for consideration in this matter is whether if there is no statutory interest, whether interest can be granted. And secondly, if there is no provision for statutory interest, can restitutory interest be granted in excess of the provisions of the Act, your Lordship?
On their own, by using their own power, inherent power, whatever.
Yes, your Lordship. So, Lordship will come to paragraph number 6, your Lordship, the issues which fell for determination of the.
Para 6 is page
Para 6 is at page number 33, your Lordship.
Huh?
33.
33. 33?
At the bottom of the page numbers are at the bottom, your Lordship.
Okay. Yes.
These civil appeals therefore raise two principal questions for determination: whether the appellate tribunal erred in denying the interest on differential amounts to the electricity boards concerned under section 62(6) of the Electricity Act 2003, and whether the appellate tribunal was justified in allowing interest on the differential amounts on the basis of justice, equity, and fair play. So the findings your Lordship will find from paragraph number 19 onwards, the relevant portions, which is at page number 37, your Lordship.
Yes.
Paragraph number 19 at the bottom of the page. The Learned Counsel for the Electricity Boards pointed out that the Central Commission has amended the Central Electricity Regulatory Commission Terms and Conditions of Tariff Regulations 2004 by a notification dated 1/6/2006 and has recognized the appropriateness of allowing interest on the differential amount between the provisional tariff and the final tariff by inserting 5A, which reads as under. Then paragraph 5A is quoted, your Lordship. Paragraph number 20. The counsel for the NTPC, on the other hand, pointed out that the price determined in the present case is for the period of 1/4/2001 to 31/3/2004. And even the orders passed by the Central Commission are dated 1/4/2005, 7/4/2005, and 2/6/2006. And that this regulation of 1/6/2006 cannot have a retrospective effect. What was prevalent at the relevant time was Regulation 79(2), the second provision of which has been quoted above, and it did not contain any such provision for interest during the intervening period. We have noted the submissions of both the councils. It is very clear that prior to 1/6/2006, there was no such provision for claiming interest for the intervening period. The very fact that such a regulation was required to be issued indicates the necessity for having such a regulation. But at the same time, it is not possible to make it applicable retrospectively. The provision for charging interest is a substantive provision which has to be specifically provided and become operative when provided. In the circumstances, the submission based on this new regulation also cannot help the electricity boards to claim interest on the differential amounts. Then, Your Lordship, regarding
But
the issue
21 is important.
21 is important. Then, Your Lordship, regarding the issue of interest, restitutory interest on the basis of equity.
Is there any residual interest here?
So here it would not be applicable because he filed the petition itself in 2017. The equities are otherwise not in his favor, Your Lordship. And
What do you mean by residual interest?
because otherwise the law is that when the court comes to a conclusion that somebody is due to receive some money which has been illegally denied to him, then to make good the loss which he has suffered by being denied the money and to put him back at the position which he would originally have been, the courts can grant interest, Your Lordship. But here, firstly, the amount of 4 lakhs itself became due after the regulations came into force. And I have enclosed it
Regulation came into force when?
in 2019.
2009. Prior to that, there was no regulation.
Prior to that, there were regulations. I have enclosed them, but there was no provision for interest in place.
Okay.
The provision for interest was specifically inserted in 2019.
2019.
So, as far as his statutory right is concerned, Your Lordship, my submission is that he is not eligible to receive interest prior to 2019 because the liability for interest only arose after 19.
After 9.
But-
Correct. Correct.
Yes, but regarding if Your Lordship wishes me to address Your Lordship on the issue of equity, Your Lordship. That issue has also been covered here. Paragraph number 24 onwards, Your Lordship, on page number 39.
Yes. Yes.
The Council for the Electricity Boards laid stress on the judgment of this court in Southeastern Coalfields Limited versus State of Madhya Pradesh, wherein this court had held that a party finally found to be entitled to relief in terms of money would be entitled to be compensated by the award of interest, which should also be payable in equity. In this matter, the appellants were operating coal mines in the state of Madhya Pradesh. The central government enhanced the royalty payable on coal, and the state government was entitled to recover the same from the appellant, who would pass on the burden to their purchasers. The appellant, however, challenged the hike in royalty in the High Court of MP. Initially, an interim order was passed and subsequently notification was quashed. On appeal, the order of the High Court was set aside. Subsequently, the state government claimed interest from the appellant at the rate of 24% per annum in regard to the period when the enhanced royalty was delayed. The appellant passed on this claim to the consumers who challenged the same and succeeded in the High Court in reducing the interest from 24% to 12%. While dismissing the appeal filed by the appellant, this court held that the interest would be payable even in equity and on the basis of the principle of restitution, which is recognized in section 144 of the Code of Civil Procedure. In this connection, it is material to note that the claim in Southeastern Coalfields was essentially covered under section 61 of the Sale of Goods Act 1930. And interest by way of damages was payable as per the statutory provision itself. The liability had been crystallized and the interest had become payable because of the failure to pay the amount as per the liability. Besides, there was nothing in the agreement between the parties to the contrary on the issue of grant of interest. In the present matter, we have the second proviso to Regulation 79(2) of the 1999 regulations, which permit the generating company to continue to charge the existing tariff for such period as may be specified in the notification by the Commission. And the notifications permitted the continuation of the existing tariff as on 31/5/2001 until the final tariff was determined. There was no provision for, this is important, Lordship, there was no provision for payment of interest levy. The very fact that interest came to be provided subsequently by a notification under regulations of 2004 is also indicative of a contrary situation in the present matter. That is, interest was not payable early.
May I please, Your Lordship? Lordship, on that particular day, Lordship, there were two judgments, Lordship. One judgment is, Lordship, that Abdul Khalek, 2022 to GLD 321.
Just a minute. Abdul Khalik, yes.
Yes. In that case, Lordship, the date was determined from the date when the Chief Electrical Inspector submitted the report. But Lordship, there was another judgment, WPC number 1296 of 2016. In that case, Lordship, the date of interest was decided as the date of accident. Therefore, Lordship,
Date of accident was how much? Which?
Date of
2012,
2011.
2000.
11. No,
So, Lordship,
cannot be.
Therefore, Lordship, on that particular date, Lordship, I placed that judgment, Lordship.
No, I've got it. I think you mean this, by Justice D. Barwa.
Yes, Lordship.
This issue was perhaps not raised in that matter.
Ah, this issue, is not there.
Matlab,
Does it
And
talk
then-
about?
Yes,
the judgment of the Supreme Court was also not placed, perhaps.
yes, Lord. And now, Lordship, so far as this judgment is concerned, just not referred by my learned.
No, no, so you are relying upon this WPC 1296 of 2016, correct?
No, on that particular date, Lordship, I just simply pointed out before the honorable court, as because, Lordship, there were two conflicting views. Only up to
No, no,
the
what is
extent,
your
Lordship.
stand? What do you
Now,
want?
Lordship, in the process, Lordship, I got one judgment, Lordship.
Uh-huh.
I'm relying on this, Lordship, 2019, 3 SCC 572.
2019, 3 SCC.
572, my lord.
The one copy you should have given. What is this? This is not done. Yes,
I have given out.
okay.
This is relating to Lordship compensation, Lordship. Compensation in terms of accident, Lordship. Lordship may kindly come to page number 580, paragraph number 15.
Paragraph
15. 15. Lordship, in that Abdul Khalik judgment, Lordship, that Rafi Menon case was discussed, Lordship. That was referred, and Lordship, that case was reported in 2001, 3 SCC 714.
What do you mean Rakhi Menon? What is Rakhi Menon?
Rafi Menon, Lordship, is a judgment which was, Lordship, passed by the Honorable Apex Court in the year 2001, Lordship. And while passing Abdul Khalik's judgment, Lordship, that Rafi Menon was referred. Now, Lordship, I'm not relying on Rafi Menon as because just now I have referred to Rafi Menon as because, Lordship, that Rafi Menon has been referred here also. Now, Lordship may kindly come to paragraph number 50.
Yes.
We now proceed to deal with the following issues. Number one, whether the quantum of compensation should be as per the prescribed rate of compensation as on the date of application / incident or on the date of order awarding compensation. Now, Lordship, we are not on that as because, Lordship, 4 lakhs is agreed. We don't have any issue on that. Lordship may kindly come to clause number 4, rate of interest. 15(4).
Yes.
Rate of interest. Now, Lordship, that has been decided at
Page number 580.
588. Rate of interest. 588, Lordship, paragraph number 30.
Yes.
As already observed, though this court in so and so held that rate of interest has to be 6% from the date of application till the date of award and 9% thereafter, and 9% rate of interest was awarded from the date of application is Mohammadi. Rate of interest has to be reasonable rate on a par with accident claims case. We are of the view that in absence of any specific statutory provision, interest can be awarded from the date of accident itself when the liability of the railways arises up to the date of payment without any difference in the stages. Legal provision is in this regard is on par with the cases of accident claims under the Motor Vehicle Act 1988. Conflicting views stand resolved independent.
Okay, you see, this judgment. You see, now the thing is, the issue is here, is whether you are claiming interest in terms of this regulation 5 or not, or regulation 20. Are you claiming under 20?
No, Lord.
You're not claiming under.
No.
So I'm going to record that. That means if you're not claiming under 20, so then what would be, as per the earlier regulations, there was no interest.
Lordship, I'm claiming under 20, Lordship.
You're claiming under 20.
Yes, yes, Lord. I'm not saying that, Lordship,
So what you're saying is regulation 20 should be applied retrospectively.
No.
Huh?
No, Lord.
Then?
If we go by Abdul Khalik's judgment, Lordship.
No.
No,
Sorry.
If we go by Abdul Khalik's
You see, first, no. Let's go. Don't mix up the issues. Union of India versus Reena Devi is not on that
Yeah.
at all. Okay, so this is not applicable to your case. Here now, your case is that this regulation 20 should be made applicable to you with effect from a date prior to its promulgation in the regulation. Correct? And that regulation of 2019 came into effect when?
It was published in the official gazette on 9th of August 2019.
Regulation 19 on
It was published in the gazette on 9th of August 2019.
9 August 19. So from this date. Now you want that this regulation, this regulation 20 should be applicable prior to 9/8/19.
No, Lordship.
No? Sometimes you say yes, sometimes you're saying no, I don't know.
Lordship, may kindly allow me to submit. Lordship, here, Lordship, on last occasion, Lordship, I simply placed those two judgments.
Correct,
Lordship,
correct,
just because
correct.
there are conflicting views, Lordship.
Correct.
I'm not saying that, Lordship, it has to be, applicable in my case retrospectively, Lordship. What I'm submitting is that, Lordship, because there were two conflicting views, Lordship, let there be a decision, Lordship, from which date the interest should be
Correct.
computed.
Now what does?
That is my only submission.
Okay,
Lordship.
okay. So what
I'm
does?
not saying that, Lordship, I should get the interest from my date of accident.
Naturally,
Yes.
you'll want it. You'll want it from that date.
I'm not, no, Lordship, I'm not asking that, Lordship.
You should.
Otherwise, Lordship, I will not get the benefit of this, Lordship, as because perhaps at that point of time, the compensation was somewhere
Less.
5 lakh.
Ah,
Hmm.
correct. Now,
in the
now
same-
when did you make your representation?
In the year 2011 only.
11.
13.
13.
When?
Lordship, I have annexed the copy, Lordship.
Page?
Page number 21, Lordship, 11/3/2013.
Claim made from 11/3. 11/3/13.
Yes.
Okay. Now, this case of APDCL versus District Legal Services is 1296 of 2016. What does it say? Where is the portion on interest?
Page number 35, paragraph number 23, last word. Under such circumstances, taking into account the provision of Regulation 5 and 6 and Schedule B of the said regulation of 2019, it is the opinion of the court that the respondent number 2 is entitled to a compensation of rupees 4 lakh on account of death of her son. Is-
No, you're reading the 24, paragraph 24 or which one?
No, Lordship, paragraph number 23.
Yes. Okay, so in the backdrop of the above, taking the conversation.
Yes, Lordship. Last 6 lines, Lordship.
Yes, read this.
Under such circumstances.
What does 5 and 6 say? 5 is with regard to the compensation amount, correct?
Yes, Lordship.
5 is with regard to compensation. What about 6?
Liability of compensation, 6 is
is the
quantum of
schedule,
compensation.
quantum.
Yeah, quantum of it.
Quantum of compensation.
So it has not gone into the issue at all.
Yes, Lordship.
It has not gone into the issue.
Yes, yeah.
Because as per this judgment, which my learned friend was referring to, the quantum will be as per what on the date of decision.
It has not gone into the
Issue of
issue of
interest.
whether when the regulation was when
Yes,
the
that is
interest portion was put into the regulation.
Yeah. And that is why, that is what, Lordship, on the last occasion I have submitted.
So this is I'm not. And what is the other view? In that Ashma Khatun?
Yes.
No, not Ashma Khatun. What is that?
Asma Khatun, madam.
Ashma Khatun.
Asma Khatun is the present case.
No, Abdul Khalek. What does Abdul Khalek say?
Abdul Khalek says, Lordship, the date should be when the chief electrical inspector conducted inquiry and submitted the report.
That also I don't
That
think is
will
correct.
be again,
That also I don't think is correct.
Yeah.
You see, because now you say in this case, it was your duty to have it done.
Yeah.
Yes.
It was not their duty to wait for you. It was your duty to have it done within that 120 days. That is the meaning or the import, I think. And since you did not do it, now you have to approach the court. So it cannot be from the date the report was. If it has been done within that 120 days period, okay. Well,
Because your lordship, the earlier regulations,
uh-huh.
they specifically relied to a report from the chief electrical inspector.
Correct.
Is present because earlier there was no regulations framed by the ARC. Notifications were issued, office memorandum were issued by the APDCL or AACB on their own for compensation. The ARC has framed these regulations, your lordship. It's very important that the, the statutory provisions which the regulations refer to, your lordship, that is section 53 of the Electricity Act, that pertains to maintenance of standards of performance of a distribution license. So the compensation actually, your lordship, is not for death. That is the unfortunate outcome. It has to be death due to a failure of the
Attributable to the
attributable to a failure of
to the
distribution
licensor.
licensee to maintain the standards of distribution. So perhaps
no licensor. He's a licensee.
I am the licensee. Distribution licensee is the APDC.
Okay, you're the
I
licensee.
am the licensee.
He's
He is the consumer.
the
So perhaps, your lordship, what is falling from your lordship would be the correct position that we have to take a decision within 120 days. If he is agreed by the decision, he can approach the AERC as provided under this regulation, because there is a provision for appeal also. Under regulation 21, your lordship. So perhaps at that stage, AERC can call for the report from the inspector to make a final determination.
No, now let us see the other provisions of this regulations.
Yes, your lordship.
Now, when we go to quantum assessment, contract,
Risk part is their lordship at 20.
no, that I'm not on that. What is the role of the APDCL when this type of accident occurs? You know, they should. You come to 12. 12 says, for intimation of an electricity accident sensor, the occurrence of 13 of electrical accident leading to loss of human or animal life shall be reported to the electrical inspector by the concerned officer of the licensee. Within 24 hours of the electricity.
24 hours.
So within 24 hours, it was to be reported by your officers. Because it says, shall be reported to the electrical inspector by the concerned officer of the licensee.
Yes,
So it was your duty to do it.
yes.
Then a copy. The chief of the concerned shall conduct an inquiry within 15 days. 15 days it was to be conducted, submit a report. Claim for that, shall make a claim for compensation, so. So you see, when you read all this,
In fact, regulation 15, sub-regulation 3 would have some relevance, your lordship.
15,
3, your lordship.
3. So all this goes to show that it was the duty of the
Now the
APDCL
duty is cast
to
upon-
initiate the process
Yes,
as per this.
yes, sir.
And
If he is aggrieved, then he can go to the appellate
that is a
commission under
different thing.
21.
so you all did not do it. And then because you did not, then you did not do it. And so you had to come here. And then this court had to direct you to make a report. I mean, I think there was an order here.
And
There's
the
an order passed by this court.
The order was passed to the chief electrical inspector, your lordship.
Order was passed. I think there was an implement or something.
Yes, lordship, implement was there, lordship. We have implemented and thereafter, lordship, direction was given to file affidavit, lordship. That order is
Lordship, otherwise, in such cases, now after 2019, a duty is cast on the APDC. But this is a case of 2011. There, these regulations I have annexed to the compilation, your lordship. There was no such provision, no such procedure was laid down. So prior to 2019, perhaps, though we had a duty, how it is to be, your lordship, how that duty is to be undertaken, that perhaps procedure was not laid up. But your lordship, PDR is made after the law laid down by the Supreme Court in the judgment referred to my learned friend. The compensation will be as per the quantum laid down on the date of decision.
May submit one.
No, what
The
order?
compensation,
Ah,
the quantum of compensation will be on the date of the lordship's judgment. Because perhaps that is what the Supreme Court judgment is.
No,
The quantum, your lordship, not the
quantum,
interest.
quantum would
Yes,
be,
yes.
yes, quantum. Interest would be from the date the regulation came into force.
Yes, perhaps,
No, it has to be,
yes.
because it is of 2011.
May submit
Because
one.
after 2019, perhaps a duty was cast on us to at least follow the regulations a lot.
Probably it was there in the earlier thing. Also.
It was not there, your lordship. I have,
It was their lordship.
no, there
Lordship,
was-
the intimation of accident, form and time of service of notice, rules 2004. It was,
Anyway, yes, what else? What else?
and the same thing, which is their lordship in, here in regulation 15, it is their lordship. Intimation.
No,
of
no,
accident,
anything, any other submission to make?
no. Lordship. From the
Okay.
date of regulation.
Then we'll write. Just write para 10, no? This one. A reading of regulation 5. Regulation 5 and 6. No. A reading of regulation 5 shows that. Just a minute. Just a minute. A reading of regulation 5 and 6 shows that the licensee, which is the APDCL in the present case, shall be liable to pay compensation to the person affected or his dependents for loss of life, for loss of human life, for loss of human or animal life, provided that the accident is attributable to the licensee, and that the quantum of compensation payable is rupees 4 lakh. The issue as to whether interest is to be paid from the date of occurrence of the electrical accident, which in this case is 16/5/2011, or as to whether, no, in terms of section 20, is the issue to be decided in the present. Correct.
it is payable
Huh.
after 120 days of the date of incident.
Within.
No, if it is not paid within 120 days, then interest will be payable.
But the issue. The issue as to whether, no, the facts of the case show that the petitioner had, that the petitioner's husband had died due to electrocution on 16/5/2011, and that the petitioner had made a claim for compensation on 11/3/2013. The APDCL not having considered the representation of the petitioner filed the present writ petition on 22/12/2017. The Chief Electrical Inspector, Electricity and Power Supply Department, Assam, was made a party respondent number 5 by this court's order dated 24/2/2020. And the report of the respondent number 5 attributing the death of the petitioner's husband by the APDCL had been made on, is it 18/11, 19, what is this? Made on
19/1/2021.
made on 19/1/2021.
19/1/2000.
The issue whether the compensation has not been paid to the petitioner till date. And as such, it is clear that the time period of 120 days of making payment under Regulation 20 of the 2019 regulation has not been complied by the APDC. As such, in terms of Regulation 20, interest would have to be paid from the date of occurrence of the electrical accident, which in this case is 16/5/2011. The problem arises due to the fact that the payment of interest provided in Regulation 20 came into effect only from 19/8/2019, when the 2019 regulation, 9/8/2019, 9/8/2019, when the 2019 regulations was published in the official gazette. The issue, as stated earlier, is whether the petitioner can be given interest from a period prior to 9/8/2019 in terms of Regulation 20 of the 2019 regulation. In the case of NTPC Limited versus MPSEB 2011-15 SCC 580, the Supreme Court was to decide whether the appellate tribunal erred in denying interest on the differential amounts to the electricity boards concerned under section 62 bracket 6 of the Electricity Act, 2003. The Supreme Court held that it was not, no, it's held that the specific provision for claiming interest prior to 1/6/2006 could not be made applicable retrospectively. When no such regulation was in existence. Correct? Yes, sir. The provision for charging interest was a substantive provision which had to be specifically provided and would become operative when provided. That's the same. That's it. Full stop. That's quite clear. Full stop. Next card. In the case of the Assam Power Distribution Company Limited versus the District Legal Services Authority and another and three others, WPC 1296/2016, which was disposed of by order dated 22/8 to 2023, a coordinate bench of this court had allowed interest to be payable to the petitioner therein. No, to the respondent number 2, I think. Is it? The respondent number 2. For the death of her son due to electrocution under regulation 20 of the 2019 regulation from 120 days to be counted with effect from 1/10/2009, that is the date of death of the son of the respondent number 2. Full stop. Next paragraph. On a reading of the judgment and order dated 22/8/23, passed in WPC 1296 of 2016, this court finds that the issue as to whether regulation 20 would have retrospective effect, that is prior to the coming into force of the 2019 regulations on 9/8/2019, had not been gone into. Further, the coordinate bench had also not been made aware of the judgment of the Supreme Court in Union of India versus Reena Devi. This is no.
NTPC versus NTPC versus Madhya Pradesh.
in NTPC Limited versus MP SEB, SEB, huh? Supra. As such, comma, this court is of the view that that no, first of all, this court is of the view that in terms of the judgment of the Supreme Court in NTPC Limited versus MP SEB, Supra, the granting of interest prior to the coming into force of regulation 20 of the 2019 regulation may not be proper. Next, in the case of Abdul Khalek versus State of Assam and others, 2022, 2 GLT 321. A coordinate bench of this court, where is that provision?
Paragraph number 40, Lordship. Last part.
Huh? Under what is under 20 again, under regulation 20?
Yes, Lordship. Having due regard to the factual situation
Ah.
pertaining in the case in hand,
Ah.
it is directed that the respondent APTCL authorities shall calculate the interest 12% per annum with effect from 2/9/2016. That is the date of submission of the electrical accident inquiry report by the respondent number 3.
Point number 3 is the,
Chief electrical engineer.
okay. What have I said? The coordinate bench of this court directed that interest under regulation 20 should be paid with effect from 2/9/16. Again, out the same thing. 2/9/16. Comma, that is from the date of submission of the electrical accident inquiry report by the chief electrical inspector. So stop. It did not. No, the accident, though the accident resulting in the death, correct? Of the petitioner's son therein had occurred on 16/7/2015. Full stop. This court is of the view that the said decision, the above said decision, as also cannot be, it cannot be followed by this court in view of the judgment of the Supreme Court in NTPC Limited versus MP SEB. Further, this court is of the view that when the report of the chief electrical inspector attributes the death of a person or animal, let's say person beyond 120 days, comma, it would not be proper to award interest from the date of the submission of the report of the chief electrical officer, as that would not be in the scheme of that would not be in consonance with the scheme, with the provision of regulation 20 of the 2019 regulation. Next part. A perusal of regulation thirteen, 14, and 15 of the 2019 regulation shows that whenever there is an occurrence of an electrical accident leading to a loss of human or animal life or injury, comma, the same has to be reported to the electrical inspector by the concerned officer of the licensee. Under section 161 of the Electricity Act 2003, read with intimation of accidents, bracket, form and time of service of notice, bracket close, rules, comma, 2005. So as to reach, no, don't say, within 24 hours of the electrical accident. A copy of the accident report has to be submitted to the secretary of the commission. What commission is this?
The Assam Electricity Regulatory Commission.
To the Assam Regulatory,
Electricity Regulatory Commission.
Assam Regulatory Electricity,
Electricity Regulatory.
Electricity Regulatory Commission. And also to the officer in charge of the concerned police station. In addition to the higher authorities of the licensing / generating company / CPP. CPP is
Captive power plant.
Huh?
Captive power plant.
captive power plant, bracket CPP. Huh? The chief executive officer of the concerned electrical circle or the station head of the generating company or CPP is to conduct an inquiry within 15 days from the receipt of a report of the electrical accident and submit a detailed report of the same to the managing director / chief executive of the concerned licensee. It does not talk about chief electrical inspector.
It does not. Why this came in was all the earlier notifications will also dependent on a report from the chief electrical inspector for payment of compensation.
The claim for compensation was to be no, the claim for compensation by the dependents of the person who dies or is injured by the accident is to be sent to the chief executive officer of the concerned circle of the licensee. And he is to cause such claim to be inquired into and determined in accordance with the 2019 regulation. Alternatively, no, wait. The claim is to be then forwarded for further processing, and the licensee / generating company / CPP are to determine the quantum of compensation on its own in case an electrical accident comes to its notice and pay compensation to the persons entitled for the same in accordance with the 2019 regulation. Full stop. All claims are to be finally settled within a period of 120 days from the date of occurrence of the electrical accident. Full stop. Next part. As can be seen from the provisions stated above, it was the duty of the licensee to immediately take note of the electrical accident and to cause an inquiry and come to a decision as to whether the 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 dependents as to whether the accident was attributable to the licensee. In case a claim was made by the dependents of the deceased or injured, the claims were to be settled within a period of 120 days from the date of occurrence of the electrical accident. Full stop. However, in the present case, no claim was made. Next para, huh? However, in the present case, no claim was made by the petitioner within 120 days of the accident. The claim was made by the petitioner only on 11/3/2030, though the death of her husband occurred on 16/5/2011. Be that as it may, it was the duty of the APDCL to have initiated an inquiry on its own in terms of Regulation 13, 14, and 15 and come to a finding as to whether the accident was attributable to the licensee. The petitioner had to file the present writ petition in the year 2017, and the chief electrical inspector was impleaded as a point number 5 in the year 2020. The report of the chief electrical inspector dated
19/1/2021,
19/1/2021
2021.
has not been denied by the licensee slash APDC. In terms of section 20, the section regulation 20, the compensation was to be paid within 120 days from the date of the accident. The same not being done, the petitioner is liable to be paid interest at the rate of 12% per annum on the compensation amount till final payment. As the 2019 regulation came into effect only from 9/8/2019, and as the Supreme Court has, in the case of NTPC Limited versus so and so, Supra, held that the provision for grant of interest could not have been made retrospectively from the date from the date the said provision came into existence. This court is of the view that the petitioner would be entitled to payment of interest at the rate of 12% per annum in terms of Regulation 20, with effect from the date of from the date when the regulation 2019 regulation came into existence, that is 9/8/2019. Accordingly, the respondents, APDCL, are directed to pay the petitioner the compensation amount of rupees 4 lakhs.
4 lakhs.
Along with interest at the rate of 12% per annum. With effect from 9/8/19 till final payment. Okay,
Lordship, let him make a, please submit the details on how the payment is to be made, because otherwise, if he does not approach us, your Lordship, and how this payment is to be made, then the interest will keep on accruing.
Huh?
If he does not approach us,
the petitioner shall submit a certified copy of this order to
the managing director APDC.
the managing director APDCL with a certified copy of this order within 1 week from today.
Yes.
And shall also submit the bank account number to which the compensation and interest is to be deposited by the APDC.
Deeply.
This petition is accordingly disposed of.
High level.
Wait, please, Lord.
Difficult.
My lord, yes, my lord, I will come to the point, my lord. I am not the other part. My lord, so far, the license, revoking the license to respond number 4, I am not.
You are
My lord, I am-
Ranjit Bora.
Yes, my lord. What has happened, my lord? I applied for the fair, sir. His respond number 4 was been cancelled. And my lord,
So you were given because his was cancelled.
it was cancelled, my lord.
So-
I was-
So because of that, you were given.
Yes, my lord. That what the order says, my lord. Now,
What order? Let us see the order.
yes, my lord.
Page.
The page your lordship will find, that is the type copy is at page 19, my lord. And- Oh, I'm sorry, my lord. No, my lord, sorry. That is at page 16, my lord. As per the permission granted, as per the book number 41 of the letter bearing number so and so, the lordship got this.
Yes.
In place of cancel license of a fair shop of Sri Kiran Bora, license is hereby granted to Ranjit Bora White, license bearing number so and so,
So you have been given license in his place.
but it's cancelled, my lord. It is
Correct,
cancelled, my lord,
correct.
I have been given now. Now,
He made a challenge
challenge
in the
and,
writ petition.
and I have not been made a party, my lord.
Doesn't matter.
Doesn't matter, that's a different thing.
That's a different.
That's a different thing. Now, in view of that, my lord, I have been granted. I have been granted a license.
Correct.
Now, for cancellation by virtue of that, there's been an order, my lord.
He succeeded in the writ
Writ
petition.
petition, my
Yeah.
lord, and on the basis of which his license has been restored.
Correct.
Like that. Now, so far, his part is concerned, I am not on that. Now, I am on the cancellation. That is why, my lord, if your lordship, why I have opposed this honorable court, that I am not on that. So that is why this honorable court, the coordinate band says, given an order having an interim stay to me, my lord. He said that it's a problem created by the department. Because if your lordship kindly see the order,
No, you see, it's very clear. It's like this. So he is going to take leave for 2 days.
my lord.
You ask for a job. He's going to take leave. So the High Court says, okay, he's going on leave. You come and sit in his place.
Right, right.
Then when his period ends,
Yeah,
then he has to leave. That's
But
all.
here,
What
it's-
the-
but here is not, my lord. If your lordship kindly see how license has to be granted. It is under the Assam Period of Articles Act, Article Orders 1982. My lord.
Hmm.
License has been granted by virtue of this.
No, your order says this.
Yes, my lord. But
Is-
your lordship kindly see
Hmm.
that what order says, my lord. Your order says, if your order says, as per the permission granted, as per the book number 44 of the letter bearing memo number so and so dated so and so in place of cancel license of fair
In
price
place of cancel license, yeah.
Kiran Bora license is hereby granted. Well, a license has been granted to me.
Correct.
Well, and granted to me by license bearing number so and so for opening a fair shop. For opening, I have been granted for opening a fair shop.
Correct.
Shop under the Morabada so and so, the order bearing so and so dated whereby the ration card of so and so, so and so. But here the order doesn't speaks about that if blood has to be restored, my lord, I'll be cancelled. So that is number one, my lord. That is why, my lord, if your lordship kindly see.
So you say that what you are saying is that your license is not temporary.
Yes, my lord, not temporary, my lord. It's not temporary. So that, that is why if your lordship kindly, well, yes, there is a difficulty. If your lordship kindly see the order, that is why the next, if your lordship kindly see the order of 2-9 of this honorable court, my lord.
2-9,
2020, my lord. 2020.
2-9.
Yes, my lord.
Yes.
My lord, the writ petitioner coming from was granted a license bearing so and so for opening affairs of under the Murabazar so and so. The states that issuance of a license was at the permission granted by book number so and so dated 16 to 2000 in place of the cancelled license of affairs of so and so. Shri Kiran Bora. In the meantime, the Kiran Bora instituted a WPC number so and so against the cancellation of the license and the judgment dated so and so. That court took a view of the cancellation of license. Kiran Bora was not as per the law. According to the direction was issued to the respondent authority to restore the license in favor of the Kiran Bora. In compliance with the said direction of the judgment dated so and so, the order dated so and so has been passed by the in charge Deputy Director Food and Civil Supply Consumer Affairs, by which the license bearing so and so guaranteed under Assam Public Distribution Article Order 1982, which stood in the name of Kiran, was restored. By the same order, it is also provided that license numbers also granted in favor of the writ petitioner stood cancelled. Being aggrieved so and so, we have specifically taken note of the WPC number. If you lordship kindly see, the beneficiary license holder under cancellation of the license of the Kiran Bora, the license holder was neither made respondent or proceeding nor a reading of this order show that the respondent authorities have.
Then you go and challenge the order.
My lord,
If you're finding this order to be incorrect, passing the writ petition, you go to division bench, you challenge the order.
no, my lord, this is an order which has been passed in favor of me, my lord, granting stay of my license, my lord. This order,
Which order?
this order, what I have, my lord, if your lordship kindly 2-9-2020 of this writ.
No, that is.
2-9, that's why it has been stated everything.
So we're deciding the issue now.
Yes, that is why you're watching.
So I'm
Well,
listening.
I know that it should have an appeal which is granting a leave, my lord. But only things, the orders which has been passed by this honorable court also, if your lordship operative person, we have also, your lordship kindly see that the order dated of 2-9-2020 of this honorable court, my lord. Para 6, my lord.
Mr. Counsel, if you want to go and argue before the same judge, that's a bit difficult because he's retired.
Retired, my lord.
Anyway, so you
But
have
there is
to.
a- my lord, there's an.
Now, what do you
judicial-
want? Let us finish
No.
up this case.
There's a judicial orders. What I want, I should, why my, so far my license is concerned, my lord. You, on the basis of what the traded article says for cancellation of this, at least I have an opportunity to give a notice to me, my lord. That's my lord, my,
Okay, no opportunity, no
Well-
notice.
but no notice, my lord. If your lordship kindly see the traded article orders, my lord. The 15-2, my lord. If your lordship kindly see,
15 to where is that?
yes, my lord, I'll give you the 15. Well, lordship kindly see 15-1 first,
Yes.
then go to the 15-2, my lord. Regarding this is cancellation of license, and 15-2 is that I have been provided an opportunity to giving.
What prejudice is caused to you?
Because I have been licensed.
When only one explanation can be, will be the outcome of any notice given to you. How can you say that any prejudice is caused to you?
Definitely, the authority may keep my license also and keep his license also, both the license. No, my lord, this area is, my lord, you have committed a mistake. That is not my fault, my lord. Had it been my fault, my lord, yes, I agree to that. It's a fault by the entire trouble has been caused by the department only, my lord. It's been caused by the department only. So I'm not saying that keep two licenses alive, my lord. My only respectful prayer before this honorable this, let his, because of this judgment, it's the finality, you cannot, unless it goes for an appeal, will not, that cannot be done anything, will not. So my also, my lord, that license shall be kept, my lord.
Difficult.
Oh, that is my prayer, my lord, and I,
And
leave to
that
your-
your prayer is that both should be.
yes, my lord. So that is my, because I cannot challenge this order because I have to go to the appellate court, my lord, if I have to go. And that attains the finality, my lord, because no appeal has been filed, no any appeal has been filed against this orders. My lord. So that attains a finality. Then so far I am concerned, my lord, because of these orders, I was kept fully on the dark that there's an, my lord, proceeding. Because the writ petitioner, if your lordship has to see, the writ petitioner, he knows about me that the license has been given to so and so, that I have been kept in the dark in the proceeding which has been,
No, even if you were a party in that writ petition, what would you say?
no, definitely I'd say.
What is your role? Because you came
No, no,
into
no.
existence only after his case was cancelled.
Cancel, but cancel is not that what your lordship.
It was not because of you that his fair price shop license was cancelled. If it was because of you,
My lord,
then-
had it been, my lord, there is a word that if anything found, my lord, against so and so, because it has been cancelled, if it's found, that that can be cancelled also, your license can be also that.
you just take this, 15. Just take this 15. I think 15.
So basically, this is my argument.
Okay.
So I know also there's a difficulty regarding because of the judgment and the coordinate bench also passed an order because there's a judicial orders also that there's a stay of my this thing because they found that there's a strong prima facie case in favor of me. That is why he has taken into consideration staying the order of my this thing. Staying.
The problem is the High Court is not made up of he and that judge or that judge. It's the High Court.
The High Court. No, I'm not saying he and she. I say that this bans and because of the fact that
No, no, it's okay. It's the he one. Just let him take it down. Okay, I'll hear the other.
my lord,
Yes.
that
There's nothing to argue.
yes, my lord. That contempt has been filed because of there's another application contempt because there's a judicial order, my lord,
Contempt for what?
for non-compliance of the orders which have been passed by the Honorable Court.
What order has been passed?
Your lordship kindly see the order. Your lordship kindly see the order of what I have said regarding.
There's no interim order passed.
Yes, yes, my lord. Yes, there's an interim order, my lord.
Where?
Kindly see the page. What your lordship may kindly take up the writ petition order dated 2/9/2020. 2/9/2020.
Yes, I've got it to 920.
Yes, my lord. Kindly see the interim order. That is why I am on that, my lord. We have also taken paragraph 6, my lord. Kindly see from
Yes.
it start from there the everything will be stated on the top. Now we have also taken note the present writ petitioner Ranjit Bora was not a respondent of so and so, and therefore the requirement of compliance with the said order may not be binding on the writ petitioner Ranjit Bora as to enable the respondent authority to take always a vested legal rights by cancelling the license granted to in favor. For the above mentioned result, kindly see, we find a strong prima facie case being made out by the writ petition and accordingly we stay the operation of the part of the order dated 29/7/20, that is by which my license was cancelled, my lord. My license of the in charge deputy director so and consumer affairs so Dr. Masa, by which license granted in favor of writ petition Ranjit Bora was cancelled.
Anyway, we'll see. Right. Heard Mr.
P. Bora, my lord.
P. Bora, the learned counsel for the petitioner. Also heard Mr. M. Chetia for
Refer number 1 to 3.
1 to 3.
Yeah.
And Mr.
And that's for the lordship in the contempt petition for the follow.
I'm going one by one. For in the writ petition, you're not there. Only Mr. M. Chetia. The writ petition. Just a minute. I'll just copy this better. It'll make it shorter. I think just let me read from. Huh? Acha. Order dated 2/9/2020, para 2, para 3. Huh? And para 4, you're right? The petitioner's counsel submits that the petitioner should have been made a party in WPC number 2176/2017. First of, however, the petitioner was not made a party therein. He further submits that as the petitioner had been granted a license to open a fair price shop in place of Shri Kiran Bora, whose license had been cancelled, the cancellation of the subsequent cancellation of the license of the petitioner could have been made only after issuing a notice to the petitioner. However, no notice having been provided to the petitioner prior to the cancellation of the petitioner's license to run a fair price shop, the impugned order dated 29/7/2020, insofar as it cancels the license, petitioner's license, should be set aside. Next paragraph. I think that's your only case, I think. Acha, he submits that, he further submits that though he cannot have any grievance against Shri Kiran Bora. He submits that though the petitioner cannot have any grievance against Shri Kiran Bora, the state respondents should have allowed the running of 2 fair price shops, one by Shri Kiran Bora and the petition. Mr. M. Chetia, the learned counsel for the state respondent, submits that the license granted to the petitioner for running a fair price shop had only been made in place of the license of Shri Kiran Bora being cancelled. As this court in its judgment dated 11/2/2020 had directed the respondent authorities to restore the license of Shri Kiran Bora, the direct result of the same required the license of the petitioner herein to be cancelled. The consequence of the petitioner, that's all. He accordingly submits that there being no infirmity with the decision of the respondent authority in cancelling the license of the petitioner, the writ petition should be dismissed. I have heard the learned causes for the parties. The order dated 12/3/2018, by which the petitioner was granted his license to run a fair price shop, is reproduced herein below as follows. Page 16 from order, page 16. The order dated 11/2/2020 passed in WPC 2176/2017 by which this court had restored the license of Shri Kiran Bora is reproduced herein below as follows. The extract of the judgment. Page 24. The last three paragraphs. Next. The impugned order dated 29/7/2020, by which the license of Shri Kiran Bora was restored, which resulted in the which resulted in the cancellation of the license of the petitioner's license. As a consequence, is reproduced below here as follows. Page 19. First step. Next paragraph. As can be seen from the above orders, it is clear that the petitioner had been granted his license only to replace the license of Shri Kiran Bora, whose license had been cancelled. Further, the ration card holders attached with Shri Kiran Bora's fair price shop was also consequently attached with the fair price shop to be opened by the petitioner. This court in WPC 2176/2017, having restored the license of Shri Kiran Bora, the natural consequence was that the status quo ante would have to be restored. As such, not only was the license of Shri Kiran Bora restored, but also the ration card holders who were attached with the fair price shop of Shri Kiran Bora had to be reverted back to Shri Kiran Bora. What's up? The license given to the petitioner being a consequence of the action taken on Shri Kiran Bora, there is no infirmity with the consequential decision taken by the authorities in cancelling the petitioner's license when the license of Shri Kiran Bora was restored by this court. Full stop. Next paragraph. The order dated 11/2/2020, passed in WPC 2176/2017, which restored the license of Shri Kiran Bora, has also attained finality as on date. No challenge has been made to the same by any person, including the petitioner herein. Next paragraph. With regard to the contention of the petitioner's counsel that no notice was given to the petitioner prior to cancellation of the petitioner's license, this court is of the view that the same does not cause any prejudice to the case of the petitioner, inasmuch as the grant of a license to the petitioner was as a consequence of the cancellation of the license of Shri Kiran Bora. As such, the decision to restore the license of Shri Kiran Bora would naturally decide the fate of the license of the petitioner. Even if a notice had been issued to the petitioner, it is clear that there could not be any dispute with regard to the fact that the validity of the petitioner's license would always depend upon whether the challenge made by Shri Kiran Bora to the cancellation of his license succeeded in this court or not. Pushkar. As such, this court is of the view that the prayer of the petitioner cannot be acceded to in view of the fact that the initial grant of a license was only due to the cancellation of the license of Shri Kiran Bora, which has been restored by this court and which has attained finality as on date. In view of the reasons stated above, the writ petition is dismissed.
Not only, my lord, there are another way, because I have applied for the fair price circle, which for Lordship kindly see page 40 of my writ petition, my lord. Lordship will find it was, I have deposited the amount for so and so, because, and my
Just write one thing. The above being said, as the petitioner has apparently applied for a fair price shop, for a grant of a license to run a fair price shop, the state respondents should take a decision on the same.
because
They should take a decision as to whether the petitioner should be granted a fair price shop if required.
Yes, my lord.
Rejected already?
Yes, my lord.
Huh?
Already we have filed an affidavit, my lord, regarding that fact, my lord. He has applied for same area, in the area, my lord, only 72 numbers of consumers are there.
Oh,
My lord, lieutenant also.
so I've already said that. Okay. Then cut that.
Mega weight of the affidavit.
78. You see, as per the notification, 50 is the minimum.
Yes, sir. The contempt,
Have you, huh?
the contempt is there because of non-compliance of this order.
What? No.
Because there is an order of stay, my lord, of my license.
Now, so now so now it's finished. What more do you want?
Not, the second item was the
Yeah.
contempt application. That's what I have pointed out.
Huh? Nothing, sir. Just right. The interim order passed earlier is accordingly vacated. Now, right in the contempt. So you're still.
At that point of time, there's a judicial order, my lord.
Yes.
There is a judicial order,
So you were not allowed to run the fair price shop over.
my lord.
Okay, we'll list it after some time. On the prayer of the party, list the matter after. Huh? Who?
The respondent in the contempt.
Okay, right. Third, Mr. So we'll let it die a natural death. We'll adjourn the matter. You implead those.
Lordship may close this one, otherwise keeping me, Lordship may close, because there is a judicial order which.
Correct. No, I understand.
There's a judicial, I know, my lord, that's a.
But they have retired. What to do?
Retired, maybe retired is a different thing, my lord.
We can still take action against them, no doubt.
My lord, because there's an order, rightly, wrongly, the passed by this honorable, that's the judicial court that stand on that day to revoke to restore my license, my lord.
But then that would be counter to the decision of the coordinate bench.
Well, that is why I'm telling you that is the orders. If your lordship kindly see the order.
So there'll be a contempt of. So you're in contempt of the other one also.
Yes, no, my lord, what is the at that point of time, what this court has found that the problem has been created by one, you have to face both will be run.
No, I do not agree.
No, that is the view of the court, my lord. I have expressed.
View of the court at that time.
At that
The
point.
view of the court now is different. Because you see, sometimes we hear arguments we are in favor of the petitioner or the respondent, then
Then
at the end of the argument, though, we change our
your
stand. from
lordship,
there.
lordship may close this one, close,
Okay, right.
close.
Heard Mr. P. Bora, learned senior counsel, assisted by Miss K. Bhattacharya. There also you say the same thing. Also heard Mr. M. Das, learned counsel for all the respondents who have retired as on date. Full stop. In view of the order dated censor passed in WPC censor, the contempt petition stands closed.
Smart. Otherwise, keeping this analysis, it will make another trouble, Virat. Item 5. Much obliged.
Yes. So you're a new council.
No, madam, I'm on behalf of SR, DTC Council.
Oh, wow. So what is your where is the instruction?
We are awaiting the instruction, but 1 week time may be allowed.
My lordship,
Okay. Mr.
He has a
P. Hazarika appearing on behalf of Mr. S.R. Rama, learned counsel for the BTC, prays for a week's time to obtain instruction. This is the matter after the week.
obliged.
In this, in three matters, we are also awaiting instruction.
My lord, what actually emanates from what I have annexed is,
You were supposed to obtain instruction as to whether the liability certificate is admitted by the Water Resource Department and as to whether the petitioner's bill has been forwarded to the district administration. What?
My lord, we are awaiting instruction, my lord. We have written to them, my lord.
Yes.
my lord, what I find is admitted liability on the part of the Water Resource Department. Thereafter, there was a development in the month of January 2024, that is at page 36. Now, here, this is a correspondence where a letter is written on 9/1/2024 to the Joint Secretary to the Government of Assam, Revenue and Disaster Management, narrating the completion of works, the specifications, the date on which the work was completed, the work allotment value, and the entitlement of the petitioner. And eventually, it was
Instruction has been received by my colleague.
What is the instruction?
The instruction is that, lordship, we have sent a proposal to the revenue department.
That's all.
so that is at page 36. That is I have annexed.
Council.
Well,
Please
well,
understand
I
that this is a writ proceeding. This is not a civil court.
I'm sorry.
So ultimately, that fund has to be released by the revenue department.
That is all right. The question is, first of all, whether this page 41, 42, this liability certificate has been admitted by the Water Resource Department, huh? Admitted. You have prepared your affidavit. Huh? And you are for whom?
I am for this district commissioner also. We forwarded it to the revenue department.
Forwarded what?
That bill proposal, lordship, because government had to sanction has to be given.
Let them file that affidavit.
Lord-
Since they have got it. Right. Yes.
Same, my lord, Revenue Department.
I have received one instruction, lordship. The proposal has been received.
Item?
10. WBC number 3894.
Okay, right. Miss RDECA, Learned Counsel for the Water Resource Department submits that the affidavit in opposition has been sent for vetting and will be filed within 2 weeks. So, Mr. Has data appearing for the Revenue Department submits that as per the letter dated 3/9/2024 issued by the Joint Secretary to the Government of Assam Revenue and DM Department, the demand proposal against the scheme has been received in the department and is under process for release of bills following due procedures. Accordingly, leave this matter after 2 weeks. That is for item 10. What about 11? Okay, 11 and 12 we have not received.
No.
Okay, Miss R, right, Miss R Deka, same thing, huh? R Deka will be same. Then Mr. F Data, some praise for 2 weeks time to obtain instructions in the matter. Leave the matter after 2 weeks.
My lord, may I pray for date in these three cases, my lord, after 2 weeks?
Leave after 3 weeks.
11, 12 same, Lordship. 12 is also there.
Huh?
12 is also there. 11, 12 same.
Okay, 11, 12 also.
12 is also.
10 years.
Yes, 10, 11, 12.
Lordship.
A date after 2 weeks. Obliged.
We'll give after that, after. We don't have time. This is item 13, 14.
13 and 14. Well, this issue has been raised before Lordship on earlier occasion also.
Just a minute.
Only, well, the question need to be decided. The approval which was granted subsequent to the completion of the work can be accepted or not.
So far as 13 is concerned, madam, I have filed an affidavit on behalf of the PWD. And
is
the
ready
reply
on
has been
that
filed
issue.
today.
Huh?
Reply has been filed today by the
Okay.
other side. In item 14, what I was praying is, madam, for 13, my lord, Lordship may fix one date for hearing, my lord, only day. Today I am not prepared. For 14, my lord, there's, Lordship may kindly have a look at the order passed on 18/9.
Well, the same issues. my
Same
lord.
issue. other-
Same issue. Well,
Ah.
the
Lordship
only
may kindly see, my lord, page, order dated 18/9/24.
Yes,
orders.
But here, my lord, there was 3 works, my lord, involved in the item 14.
yes.
Now, my lord, as per the liberty given by the honorable court, we have opened the technical bid of two tenders, my lord, and we have found that the petitioner is not eligible under 5 grounds.
Okay.
That I have placed, my lord, and honorable court directed, gave the liberty to open the financial bid. Now, my lord, the third, my lord, tender, we have now opened, my lord, again, my lord, we have found that he is not eligible on 5 grounds.
Okay.
So that I liberty I pray, my lord, if he is financial bid is, my lord, he is L1. In that case, my lord, he can pursue it. Otherwise, it will be an academic discussion. And my lord, item 13 can be decided on a later date, my lord. Today I have some difficulty.
Well, the
That's
issue
how-
is same. Well, they are just delaying disposal of the, well, of this particular question. My lord, Lordship will find in earlier
I'm not
tenders.
delaying, my lord.
Just a minute. Item 14, let us see one thing. One at a time. Yes.
Lordship will see whether that chart, my
In item 14, he has applied for which work?
for 3 works, my lord.
For 3 work. Okay.
That Lordship will find page, one is at page, my lord, yes, page, my lord, 95. 93, 95, and my lord, 97. These are 3 works.
Okay.
His apprehension is that, my lord, on the ground in which, my lord, the tender in item number 13 was rejected. In these 3 tenders also same will be on the same ground, it will be rejected. So on apprehension, he approach the honorable court.
Okay, but it is not
I
the case.
submitted that, my lord, let us open the tender, we will see, my lord, if leaving aside that ground, if there is any other ground on which it can be, it is rejected. And, my lord, on 5 ground, it has been rejected now.
Where is that?
That, my lord, Lordship will see in the very first 1 or 2 pages, my lord.
Yes.
Steno engineering is there.
Tenor engineering. Drilling Tata. Yes, what is to be done?
My lord, you'll find, my lord, the lead, there's three, my lord, tenders, my lord, which are the issue in this repetition, my lord, and this court has directed not to open the bids. Thereafter, taken the leave to open the technical bid without considering the my lord, the validity of the work experience certificate that was submitted by me. So accordingly, two they have opened, and there they have mentioned, though my lord, this ground, but then they have not taken into consideration for my lord declaring non-responsive, but they have taken four more other grounds.
Then you have to challenge those.
And I have challenged those, and this court has found that these are also my lord non-existent ground and they are in state.
In one, my lord, in one.
And the
tender,
other one,
it is another
my lord,
challenge.
I'm
Lordship
sorry,
has
the
stated.
other one, they themselves have withdrawn. After technical bids were open, financial bids were open, one they have withdrawn by themselves. And the second one, they have rejected me on the four grounds, and this court has stated that. Now, in both the issue, in writ petition, only the issue whether the approval granted by the authority, my lord, can be accepted or not. That is the only issue. They have filed a
Similar to one that Meghalaya case, my lord. Here it is on Arunachal. He was a subcontractor. Without approval from the authority, he completed the subcontract. When we verified, they said that we have not given any approval for subcontract. And we are also not aware whether the work has been completed or not. And on that ground, in a work where he applied in Borpeta, following that experience, it was rejected. His bid was rejected. Subsequently, he has obtained a, my lord, ex post facto approval of the subcontract. Now it is there in record, admittedly. Now, whether that will suffice now or not, my lord, that's the whole issue. In the first case. And in the first case, it's not the L1. So technically, my lord, we have issued a work order also, or it's under process for issuing a work order. Only that issue is to be decided because you will.
Okay, now in these cases, what to do now?
Well, Lordship will allow us at least if he is not L1, then again, my lord, we'll have to decide the item 13 only, on one point only. No point, my lord, keeping a
Okay,
public-
so,
public
okay, so
contract
if you're not L1, then you may be allowed.
Yes, then we will not, my lord, issue the work order.
I know, my lord, though they have not given me this, my lord, the technical bid opening, evaluation of
So
the
it will be
technical bid.
uploaded, we are yet to
My lord,
upload it.
Yes, yes. My lord, this will be the same what they have done in the earlier one. It is a stereotype in the earlier occasion. My lord, the Lordship will have to hear, my lord, hear me a little.
No, they're only cases. If they open the financial bid, and if you are not L1, they then continue because you're not going to get it anyway.
No, thereby what is happening, my lord, here? This is a small issue, my lord, that can be decided, my lord, whether this approval can be accepted or not. That much, my lord. And they have filed their extent, my lord, affidavit has been filed. But because of non-taking decision on this, my lord, writ petition, one after another tender, my lord, they have been, my lord, rejecting me. Therefore, this apprehended, my lord, this second writ petition has been filed. Now they have able some more, another four set of
Some fault they're finding everywhere.
fault. And now, my lord, this will continue again. And if this particular, my lord, writ petition is decided, it will hardly take 10 minutes. At least I'll take only 5 minutes.
He's not ready, he says.
Because Lordship will see his affidavit. Today it may not be taken up.
Beyond whatever is record, is there in the record.
Yes, my lord, the affidavit has been filed, my lord, 2-page affidavit has been filed. Only ground they have said is that under particular clause 4.2, my lord, the prior approval is necessary. But the clause itself does not say so. And it was a procedural lapse, my lord, or committed by the authority as well as being a first-time contractor, I did not know that approval is required as such. So therefore, when I submitted, my lord, the tender in respect of the Borpeta, my lord, tender, they have rejected me. I immediately realized that approval has, though procedurally they have been maintaining. So I have approached the authority and they have issued me the approval. Now, secondly, in the tender, they have rejected me on the ground that work completion is on a prior date and the approval is on a later date. That is the ground. And now, my lord, these two have been, my lord, when.
Anyway, so what to do?
My
They are going
prayer
to
is,
the-
my lord, Lordship will post the, my lord, other case next week, any day, my lord, convenient to this honorable court as well as my land senior. So far as this part is concerned,
Next-
let it be
next
my
week,
other,
next-
what's the point, my lord?
It's so
No, my lord, this is the point can be decided, my lord, even, my lord, if today not ready, tomorrow it also can, I'm, sincerely, I'm
Tomorrow,
something
my lord, some medical.
But
equipment,
I'm-
others, I can, yes,
what
tomorrow
I'm
is others
submitting, it will
possible.
take hardly 5, at least I'll take only 5 minutes.
Mr. Council, y'all will take 5 minutes, I'll take 2 hours. What do you think? And
No, no, the lordship will.
you see,
lordship-
y'all make submissions in 5 minutes. We have got to write judgment on that 5 minute justifying our finding. It takes around 2 hours. It is not that it's for, I know, I've been a lawyer, I know.
lordship,
And I know as a judge what we do.
But lordship will kindly consider my sufferings, well, one after the other tenders are also there, I am submitting that, then again I have to come to this
Correct,
court.
correct.
And then they will say, let me allow me to open.
We'll fix a date for after this. We'll fix a date, finish everything.
Well, then again, my lord, what will happen? We have, at least we have got 5 rounds, my lord, in this particular third also. What about that? Without that, we can
Correct,
challenge to that. Without uploading in the, my lord, portal, can you challenge it, my lord? Once it is
That-
uploaded,
my
you'll have
my
to.
lord,
You
my lord,
upload that, then you come
No,
No,
without
the-
leave, we
the-
cannot, there's a,
to upload this.
Yes.
but
that's
that's
why I'm
been
saying.
ordered.
So let him
There's no
upload.
leave, That
No,
is
no,
not
what-
given in the,
Lord,
his case can be decided
lord,
any day,
whether-
my lord,
whether
tomorrow
my-
also or Monday also, provided convenient to the honorable court. That's what I'm saying, my lord.
Correct, correct.
My lord will kindly consider, my lord. The decision of the tender committee, my lord, evaluation committee is not at all an issue in either of these writ petitions.
No, no, Mr. Council,
Only
that,
issue,
Miss-
only
no,
issue.
no, according that, you see, according to you, your only issues with regard to that experience.
Yes,
Now, the thing is, their issue is,
Additional.
it is not only your issue that has to be considered. Their issue has to be considered. Their issue is, besides past experience, there are 4 other issues for which your technical bid has been disqualified. So, even if you succeed in one issue, you have got to make a challenge to 4 other issues.
We can, unless we
My lord,
upload it, how
and
can we challenge?
my submission, my lord, these 4, my lord, will be the just reproduction of the, my lord, grounds which were they have.
Maybe, but whatever, it is still there. What to do?
Ultimately, public work should not be held up, my lord. That's what I'm
I'll be
saying.
again invited to, my lord, file other writ petition.
No, no, we'll take this, we'll take up one only then.
Yes.
With this we will allow them to upload the technical bid. Technical bid evaluation still. Since they have been allowed to open.
Yes, my lord, liberty was granted, my lord. In phase 3,
You know, the response is permitted to upload the decision.
no, in 2 works, my lord.
In-
Third
huh?
work, my
In
lord, I am
two.
placing it today. I
Okay.
am seeking the liberty.
Oh, so it's
All of
already
that
been
part, my
done.
lord.
In 2 out of, you have challenged 3 works here, correct?
And what,
And 2 out of 3, court has already granted.
that's why, my lord.
Because of non-decision on this issue, my lord, 3 writ petition came to be pending now, my lord. Now, again, this will go, another 4th is going to come, my lord. That is what, my lord.
No, but it's in this writ petition,
Lordship.
this writ petition is with regard to 3 contracts, correct?
3 con-
Then 2 of them have been allowed, third one only, that's all. Right. Heard Mr. P.J. Sakil, Leonard Senior Counsel for the petitioner. Also heard Mr. B. Gogoi for the PWD. Mr. B. Gogoi submits that the technical bid of the petitioner in relation to which one?
Yes, my lord. It is page 70.
90.
97.
97.
Yes,
In relation to
97.
in relation to NIB dated 27/6/2024 has already been opened and the decision of the bid evaluation committee has been taken. He accordingly submits that permission may be granted to upload the decision of the bid evaluation committee from inasmuch as this court, while order dated 18/9/2024 has already allowed uploading of the decision of the bid evaluation committee pertaining to in relation to NIB dated just a minute 93 and 95 I think. NIB dated 14/6/2024. Acha, both are all
Same date, my lord.
all-
Same date.
14/6/2024. Oh. One is other one is 27. On considering that this court has already granted the respondent department to upload the decision of the bid evaluation committee in respect of the technical bids pertaining to two other contracts, the petitioner is also allowed to, the PWD is also allowed to upload the decision of the bid evaluation committee in respect of the NIB dated 27/6/24.
27.
Then when do we fix?
My lord, any day convenient. Next week I'm.
My lord, without, my lord, only
Tuesday?
thing, my lord, without further delay, my lord, I pray, my lord, because
Yes, my lord, I
on the
will.
very first day,
How long will you take?
5 minutes, my lord, not even 5 minutes also, my lord. Because affidavits, all the
Yes,
pleadings
No,
are.
no, no. What do you mean? All the pleadings are there.
Lordship, my lord.
Your submission has to be 5 minutes.
Yes, yes.
Encapsulating everything.
Yes, yes, my lord.
Yeah, all the pleading.
Issue has come down whether that approval
Tuesday,
can
what
be
do we have?
accepted or not.
Tuesday, we have got anything? We have got something.
Thursday one. Thursday.
Thursday holiday, Friday holiday.
Oh.
Ah. Very difficult. Next week, to it's very. No, we have
Monday
fixed.
is the last item, my lord.
We have fixed some items. No, that is the
Yes.
problem. Every
No,
day we are
I'm saying-
fixing items.
On fifth, my lord.
You see, today is the hearing day. We are still stuck in this admission thing. No more. I don't think we have to keep this day free now for hearing.
Fifth or seventh, my lord.
Huh?
Fifth or seventh, my lord, if convenient. Fifth or seventh.
Fifth, I think we have got.
Well, on fourth, my lord, as the last item. Because otherwise the issue is very short. Only
Right,
on
so
that
even
part.
he agrees, my lord, that's,
Fourth, okay, fourth.
Yes, we'll try to make it fourth.
This is the matter of fourth.
And my lord, we are
Both
liberty
the
to-
repetitions, no? Fourth.
we will be at liberty to open the, my lord, financial bit, and I will, my lord, declare it before the honorable court. If he is not L1, he not to challenge the, my lord, technical bit. He will be relieved from that burden, madam, as well as the honorable court.
Well, we will see. Next date we'll see. You first upload this.
now to prepare the second, again, fourth request.
No, if he is L1, that's why I'm saying, if I open.
No, it's better we do it little by little. Then you'll have more work.
Yes, that is there, but.
Obliged.
Obliged.
May I please, your Lordship? Lordship, item 15, 16, and the series, my lord, 24 to 33.
Ah.
Advocate General is appearing, my lord. He is not well, my lord. So I'm praying for a week, my lord.
This entire year is going.
Yes, my lord. My lord, he is not well, on medical ground, my lord.
Okay.
I'm praying for a week.
What to do? AG is not well. What to do?
Interim is there, Lordship.
No, it's not that. This, I mean, this 29/6/24, July, August, September, October is finishing now.
My lord.
4 months.
My lord, after a week, Lordship can dispose it of my.
Okay, right. Yeah. Mr. S. Datta appearing for the state respondent submits that the AG Assam will be appearing in this matter. However, as he is unwell, he prays for adjournment. And this is the matter. Well, give it date.
As per court's continuity.
Only thing is that we are suffering a stay.
I know, that's the problem, but what to do? No, not 14th. 14th, no. Before that, we don't have time. No, 7th, we have got that big one.
PK Goswami.
Huh?
PK Goswami will be appearing in this matter.
Yes, then Mr. Das is there. Mr. BD Das is also
He
there.
is also there.
Huh?
12th is hearing day.
12th.
12th is hearing day.
Right, 12th.
Item 15, 16, 24 to 33. Well, this matters 15 and 16 may be tagged with others. Maybe
List the list have the identity. List this matter along with transfer, huh?
15 and 16 both.
15 and 16, huh?
Department has not communicated the affidavit from the.
Right now, I am giving this.
Okay, give the copy.
This is. Take page on.
Already busy already.
Give them.
Yes, yeah, already on the last date I have circulated on many advertisements.
You do.
Okay.
Finish.
Interim all.
Interim order to continue till the next week.
So I need some time to file the countermand. Today,
Reply, you mean reply?
yes, reply.
I have only brought on record some subsequent developments, nothing much.
Then.
Basically, case is ready for hearing, otherwise pleadings are complete. So, my only thing is if, could it be taken up on 14th of November, my lord? Because today I find that my lord is fairly engaged. Other cases are also there.
Oh, if you are not ready, I am ready, not an issue.
Because
Today
Mr.
they have-
Chaudhary, I was told,
Today they have filed the additional affidavit.
I may not even press it if that be the case. If Mr. Chaudhary can come, I will not even press the additional affidavit. Because only certain developments are there, I thought I should put it on record, that's all. May not be very, very important otherwise. But if Mr. Chaudhary is unable to come, tell me that, whether he's in a position.
No, actually, he is in late in court number 1. When the matter will be finished, my lord?
I don't know, I leave it up to you.
Then it may be taken up on 14th.
14th will be difficult, 15th is holiday. Huh?
12th and 14th. I was told that my lord has fixed many cases on 5th and 7th also. So
All the hearing days are fixed. And
my lord, we'll take our chance. We may be lucky. Maybe
7th, I don't think you'll be lucky.
5th.
5th or no, we have got fixed too many.
5th and 7th, so many people.
Huh? Until
19th, I'll be in Itanagar bench. That also is it. 21st, could it be, my lord?
21st.
21st.
You file whatever, you want to file something? No.
Today I have received, my lord.
Okay, right.
Going to
Mr.
SK Ghosh.
S.K. Ghosh appearing for the writ petitioner submits that additional affidavit has been filed today by the respondent number
226.
226. He accordingly needs time to go through the same and file an additional affidavit if required.
Much.
Whereas allowed, additional affidavit, if any, should be filed by the petitioner. Oh, reply affidavit, no.
Reply.
Reply affidavit, if any, should be filed by the petitioner within 2 weeks. List the matter on.
My lord, could it be for admission in that case? Because hearing otherwise, it becomes very difficult. Because it's the construction of embankment. That's why, my lord,
Construction
it's
of?
construction of embankment in the river Subansiri. So project is held up that way.
Because of this.
Yes,
No,
my
no.
lord, because reason, my lord,
That is in the lower Subansiri.
yes, my
A
lord.
small portion of
Two-
part.
But, 2 kilometer stretches are there. So in most of the part, the embankment construction is complete. This 2 stretch kilometer part is left. So with the onset of monsoon in the month of April, May onwards, it will be very difficult. So before that, we would like to get it
This lower
completed.
Subansiri project has been going on for the last 20 years.
But my lord knows very well the reasons behind that. Plenty of litigation. We are trying to resolve it. We are doing our best. The construction of dam is almost complete, my lord. 80% of it is over.
It was supposed
is
to
the
be
lowest-
functional. It was supposed to be functional prior to COVID.
But my lord knows very well the reasons behind that.
I don't know, because I went there also.
I have been told, My lord has been to that place. My lord, could it? We will try, my lord. So for admission hearing, if possible, my lord, because admission, if it comes, we have better chance.
Oh, okay. In the admission column,
Very
on 21.
Marketist. May I please, your lordship. Also, this matter, with all respect, it was substantially heard by Honorable Justice S.K. Mehdi on 5/9/24. And thereafter, my lord, an observation was made, of course, my lord, without touching the merits of the case. If some compromise can be meted out. 10, my lord, this case was listed before Honorable Justice U.K. Nair, who had, my lord, expresses reservations that this matter was substantially heard by Justice Medhi, so let it be heard by him. So thereafter, again on 27/9, this matter was listed. And my lord, under that circumstances, if I may pray, my lord, that since this matter was substantially heard by Honorable Justice S.K. Medhi, let this matter be heard by him, my lord. Because on 5/9/24,
Yes, sir, this matter is not to be treated as part heard.
not to be treated as part,
Yes,
that is true. That is
So
true.
can I say that it should be heard by him? I am not the,
No,
then
absolutely not, absolutely not.
I can give you adjournment, that's
My
all.
lord, my lord, that much, my lord.
Any objection?
No objection. I shall not do that, my lord.
He wants to go, I understand because since Justice Mehdi knows everything now.
I can with all humility, because I am in a now catch-22 situation.
Actually,
But
my lord, what
I-
happened, my
I
lord,
must,
Justice Medhi not wanted to interfere after seeing the merit.
Yes.
He said that if some amount can be paid, but our instruction is that it's negative.
so.
I don't know, I don't know, what is your prayer? You want it to be received before Justice Mehdi, but Justice Mehdi has categorically stated in the order,
Yes.
this matter is not to be treated as part heard. Now what to do? Can I say that it should go before the appropriate bench?
But under that circumstances,
But I cannot do that.
Lordship may kindly record my submission that I am seeking a short adjournment, my lord, that much, my lord.
I don't. So if you object to this,
Short adjournment, that I not oppose, my lord.
how much time?
1 week time, my lord.
A prayer for adjournment has been made on behalf of by Mr. R. Bor Pujari, learned counsel for the petition, which is not objected to by Mr. G. N. Sayawala, learned senior counsel for the response number 2. Accordingly, this matter after the
I am just taking a chance, my lord, with all that.
bench hunting.
No, my lord, not my lord.
At the end of the day, that amounts to bench hunting,
I'm obliged.
hoping that it will go back to him. Is it? I don't know.
My lord.
Anyway,
I'm so obliged. I'm so obliged.
yes.
My lord, this, my lord, on the night of 15/12/2014, my lord, the petitioner's meter caught fire.
15.
12, my lord, I have prepared a document also. I can get my pen also. My lord, just, oh. The short, my lord, note, your lordships can show it, my lord, because the answer, I'm just paying, my lord. During the night of 15/12, petitioner meter caught fire and became non-functional. By later, the petitioner intimated the area manager with the request to take necessary action for installation of the new meter at the earliest. On instead of approaching later, the MPI wing of Jorhat SD1 visited the floor mill of the petitioner and inspected the burnt meter on 17/12/2014 and see the meter and prepared an inspection report to the police. Meter cabinet found burned in seal condition, bearing seal number so and so. So meter was found to be sealed, madam. The cabinet glass was found in broken condition. HD meter was found fully burnt out condition with 7 core cable also burnt in the metering end. No trace of burnt marks at the CT, PT end and other accessories. That is LA, DOB, DOQs. Photographs have been taken for further examination and evidence. As per verbal discussion with the CEO, EC, the meter cabinet with remains of the burnt meter house inside is hereby sealed in seal condition in presence of the consumer and applicable official for ascertaining the cause of damage at TNC lab, Jorhat. However, the consumer is instructed to provide an undertaking stating his willingness to pay the cost of a new meter, CTPT, and 10 core cable at the After expiry of about 3 months, the petitioner was informed that physical verification of the meter would be conducted on 27/3/2015 and asked the petitioner to remain present to witness the physical verification process. Accordingly, the representative of the petitioner concerned appeared to witness the physical verification and testing on the date fixed. After investigation, a minute of the physical verification and testing was prepared. A fair perusal of the minute makes it clear that the meter was found completely burnt condition. Metering details were untraceable. As such, a judicial authority decided to send the meter for forensic testing and analysis in order to find out the exact reason behind the burning of the meter and to ascertain the metering, my lord. That is at page 39A, my lord. That is there, my lord, also in the 39A, my lord. Now, after about 10 months, my lord, this is important, my lord. After about 10 months, suddenly the prisoner received a letter, that 13/1/16, informing that further physical verification will be conducted over the aforesaid siege meter, asking the petitioner concerned to remain present on 21/10/16. My lord, this is peculiar, my lord, after more than a year. Responding to the aforesaid letter, by letter that petitioner informed the authority having decided to refer the matter for forensic test and analysis. There remained no scope for further physical verification and inquired from the authority regarding the applicable provisions of law which authorize the judicial authority to undertake second physical verification test over the meter. That too after such inordinate delay with a request to fix another date. By letter dated so and so, the responding authority fixed.
No, before that,
Yeah.
where is the forensic report?
Forensic report they have not produced. They have not produced, my lord. I
Then-
don't know whether forensic report is in their favor or not.
So, the findings of the forensic report are mentioned in the impugn order.
If you want to avail.
Yes, of the order of the appellate authority, it is mentioned.
I'm coming. That is there only.
Right letter dated.
By letter dated so and so, responsibility fixed 29/1/16 as another date for physical verification test but failed to apply. The petitioner about the provision of law empowering the authority to undertake test or further physical verification over the meter. Also failed to apply, supply the video photograph dated 27/3/15 and failed to apply about the forensic test analysis report. The prisoner filed objection to the further physical verification and filed letter dated so and so. In the name of physical verification on 29/10/1/16, the seal affixed over the meter cabinet box was broken and the meter was totally dismantled. And thereafter prepared a false report, minute, and petitioner was asked to sign the said minute. The petitioner wanted to record its comments and observations on the minute before signing and asked the respondent authority to let it do so. But as the authority did not allow the petitioner to record its comments observations, the petitioner refused to sign the minute and by the email letter itself informed the concerned official authority about the reason for his refusal to sign the physical verification report. On 31/1/16, which was Sunday, the Sub-Division India Jorhat Electoral Sub-Division 1, Jorhat, served a notice of disconnection, informing that the petitioner was involved in the act of malpractice as per the so-called statement of at Annexure 1, and asked the petitioner to visit his office on 1/2/2016 to collect the provisional assessment bill. But no statement of the alleged involvement in malpractice was served upon it, as the physical verification dated so and so failed to establish any case tampering against it. The petitioner received a letter, notice of provisional assessment order dated 1/16, forwarding therewith provisional assessment bill dated 1/16 for an amount of rupees so and so, 37 lakh and all. Along with a statement of calculation of assessment bill, the assessment bill was raised for a total period of 12 months, as if the alleged tampering continued for long 12 months, without there being any material in the support of the same, and ignoring the previous inspection reports. The aforesaid provisional assessment order and the bill was purportedly issued in terms of section 5A4 of clause so and so supply code on the ground of theft of electricity. Therefore, the terms of provision contained in 154(5) the Electricity Act, civil liability only imposable upon a consumer, the alleged theft of electricity can be determined only by special code posted under section 153 of Electricity Act. And the assessing officer do not have the power to adjudicate any such matter as would be evidence so and so. The Assam Electricity Regulatory Commission does not have any power to prescribe such a provision of.
Yeah, basically, what is this? I thought this is a small synopsis. I mean, it's bigger than the,
Actually, everything has been given, my lord, here. I did not, my lord, that is why, my lord.
it's bigger than the writ petition, I think, longer than the writ
No,
petition.
my lord,
huh?
very short, my lord. That is why I have, because I have quoted that objection also. Being agreed with the legal provisional assessment, the order, synopsis is there in the petition itself, my lord. So I have prepared everything, my lord, here. Being aggrieved illegal provisional assessment bill, that so-and-so petitioner so-and-so filed this detailed objection as per section 126(3) of the Electricity Act and the responsible area manager. On the day the petitioner asked for adjournment and fixed the matter on 11/5/16 and verbally said that there was no necessity for appearance of the petitioner respective on 11/5/16. The area manager raised the final assessment bill of 37 lakh and odd on 19/5/16 and passed the final assessment bill order on 20/5/16 on the ground that no representative of the petitioner was present during hearing without any individual. The provisional assessment bill was considered as final assessment bill. As such, the petitioner preferred an appeal before the appellate authority, being appeal number so-and-so, the deposit 50% of final assessment amount of 18 lakh so-and-so, together with appeal admission fee. During the hearing, the finding of the second verification of the point meter was placed, and the said report, it was mentioned that with the external wires, a foreign circuit was installed in the meter over the PCB. On such basis, the area manager justified that there was clear case of interfering with the meter. Well, this is a case, my lord, your office find. The meter was totally sealed. It was burned. Well, where the question of my lord, integrity, well, that is the say. The said facts were totally denied by the petitioner during the argument. However, such facts were completely ignored by the appellate authority. After perusing the documents submitted by PDCL, authority decided the meter was burned due to internal short circuit, and the main cause of burning may be either external impact or injection of external fire to the meter through the broken window of the sealed meter cabinet, for which consumer is solely responsible for insurance. And also held that petitioner involved in malpractice of a foreign circuit was found and seal of the meter cabinet was found intact. When seal of the meter cabinet was found intact, my lord, how one person can inside it, my lord, the meter something foreign substance? However, one side of box is hinged, which gives opportunity to open the box. My lord, this is the appellate authority, my lord. Your lawsuit see in every, my lord, door also hinge is there. Suppose if hinge is open, my lord, can it be put again there?
I don't know, a lot of fake stuff are
No,
going on.
this is a hinge, my lord. I'm surprised, my lord, to see the observation, my lord. So the hinge, my lord, it opened again, my lord. Actually, totally, my lord, absolutely. That's pure, my lord. My lord, it is totally sealed, my lord, condition. The first, my lord, when inspection was done, the observation you also have seen, it was found that it was sealed. Second time also, they have inspected. Inspection report was prepared. It was totally, my lord, fully, my lord, sealed. Third time, my lord, they have dismantled it, and thereafter this report has been prepared, my lord. This is the important, my lord. So there being no concrete finding conclusion regarding unauthorized use of the space from other so and so. Well, this is my yes, my lord, and even my lord, as per 126 also, the authority must to the conclusion that my lord, unauthorized use of electricity made for the entire period, my lord. Nothing is there, my lord. The lawsuit see, my lord. Past consumption has not been seen. What is there? They prepared the bill for entire period of 12 months, my lord. Your lordship may just see section 126, madam.
No, let's finish everything.
Yes,
Please read
yeah,
it.
yes, ma'am. The cabinet box being hinged do not conclusive prove tampering of the meter, especially when the seal was still intact. A prior page of the order passed by appellate authority revealed that appellate authority merely suspected tampering because of the hinge. Appellate authority are in law as well as in facts in presuming tampering of the hinge in the cabinet box. So that the presence of foreign circuit is impossible to hold that without touching, breaking the seal placed over the cabinet box. The petitioner or for that matter, any other unauthorized person could have implanted anything inside the meter leading to burning of the meter, so as to warrant initiation of any proceeding of malpractice, tampering, unauthorized use of electricity within the meaning of section 126 of the Electricity Act. Moreover, before preparation of a bill, the authority must come to a conclusion that there was an unauthorized use of electricity as per section 126, 1 and 5, that the assessment can be made for the period for which unauthorized use of electricity was there. But they did not look into and to look into, look any past consumption of electricity by the petitioner. And where there was any base consumption for the period for which assessment was done, further videography was taken. So to have access inside the meter, the authority itself cut and broke the various seals and wires and removed the plastic tape of the meter. The answering deponent further to submit that in order to book a consumer for malpractice tampering on meter, it is incumbent for the licensee supplier to establish that any electrical measuring parameters have been tampered or rendered deficient, resulting in recording less consumption in comparison to the actual consumption or tap relation. In an instant case, meter in question having been burned completely, there is no material with the authority to establish that any electrical measuring parameters of the meter were tampered, as would be evident from the minutes of the physical verification testing report dated 27/3/15. As such, it can safely be concluded that a false case of malpractice tampering has been projected against petitioner. There is no finding that the meter was recording any lesser reading prior to the date of burning of the meter, resulting in any benefit in the consumer, and loss to the distribution supplier. And admittedly, on or after the removal of the burnt meter on 2017-12-14, no electricity whatsoever was supplied. As such, there cannot be any question of the petitioner making any unauthorized use of electricity or deriving any benefit within the meaning of 126 of the Electricity Act, save and except the unmetered consumption during the period 15 to 17 of the meter and the date of removal of the burn meter, the unmetered consumption of 3 days. The aforesaid provisional assessment order bill purportedly issued under terms so supply code on the ground of theft electricity. Therefore, in terms of provision of control, contained in section so. Let me.
So you went in, you applied 126 also.
Yes. 126. My lord, your lordship, my lord.
So this is, you went in appeal, everything after appeal you have come here, is it?
Yes. Your lordship may just see that product. My understanding is that here, my lord, it says that forensics laboratory Guwahati refused to perform the analysis. It has been observed in the appellate report.
Testing report is quoted there at page number 61 is there.
Testing report, I'm coming to that, my lord. It will also. At page 61 top, my lord. They have never informed, my lord, but the forensic laboratory Guwahati refused to perform the analysis as intimated by Deputy AGM TNC Division Jorhat due to non-submission of a specific court's directive. As such, for conducting next physical verification, a date was fixed in consonance with the appellant. The meter was opened from a sealed cabinet box in presence of the appellant and removed the top cover of the meter for analysis. The finding of the two physical verification burnt meter is proved. The meter was in burnt condition along with the modem. There, which external wires a foreign circuit was installed inside the meter. This is second, my lord, report. That is why, my lord, I have not signed it. But when the question of second, my lord, when that first inspection was done after the burnt meter, what is prepared, and secondly, my lord, they have the inspection was done. And everything has been recorded, my lord. It was found, my lord, the meter was sealed, my lord. In the sealed meter, my lord, there is plastic cover also. Beyond imagination, my lord, that any external thing can be placed inside that meter. This is one aspect. Secondly, my lord, 126, my lord, your lordship might just see. One 126, 105, my lord, mainly.
Page 105.
Yes, 126. 126, 151. Act. Yes. 161, 126.5.
Yes.
If the assessing officer reaches to a conclusion that unauthorized use of electricity has taken place, the assessing officer shall make the estimate for entire period during which unauthorized use of electricity has taken place. And if, however, the period of for unauthorized use of electricity has taken place cannot be ascertained, such period shall be limited to a period of 12 months immediately preceding the date of it. My lord, where they have decided, where they have found it. Nothing, my lord, it is also fine. My lord, the original order, which is at page 58.
Huh?
Page 58. That is the order. Page number.
Page 58
Yes.
of the writ petition.
Yes. The previous or date of hearing of so and so on provisional assessment bill. It was postponed by its number on the last and final date for hearing was fixed on so and so, which was informed to the consumer by date number so and so. And it was to, but referring to provisional is present, no, without any information, and the provisional assessment bill was considered. And this provisional assessment bill was prepared for 12 months. That is at page 54. I did not understand where they have found it. 126.5 says that they have to find out where unprejudice is there. They have not seen my past conjunction also.
What is your past consumption?
No, past conjunction, but they have to see whether originally there was heavy load. Then
So I am asking you, what is your past consumption?
past consumption means prior to burning, my lord.
No, so where is it? Where is your bill?
No, that is what, my lord, they have to find out. That is 126.
No, you will be having a copy of the bills.
No, I have not got that, my lord. But they have to find out. No?
Correct, they have to find out, but you'll be having a copy now.
No.
When you must be paying electric bills also.
Yes.
How do you pay it? Without
These are
bill.
there, my lord, but I have not annexed here, my lord.
So let us see from there, what is your past bill? Let us see.
Then
You
I
bring,
have to bring it, my lord.
you do bring? Let us see your past bill. Yes. And where is the past bill?
Otherwise, the units that were built in the past 12 months, that the units are reflected in page number 54.
You must have been sending them bills.
Yes. What the amount, the units that were built for the period from December 13 to November 14, that is otherwise reflected in page 50.
So now with the bill that you have submitted now against him, the provisional assessment or whatever, what is the unit?
The statement, your lordship will find at 54 as that formula is there as per the supply code, your lordship. That formula was.
No, what is the units that you have billed him for?
Yes, because we could not find out the actual period for which the unauthorized use was going on. We are the law mandate said we have to calculate it for 12 months. So we have calculated as per the formula given in the supply code. As per that formula, the total units as per the formula is 4,69,000 units. And what he was actually billed was 1,31,238. So we have subtracted that from the formula and then we have billed him accordingly on the balance. Because the formula because once the meter has been tampered with, your lordship, we do not know what will be the actual consumption. So the formula is given under the supply code. We apply that formula, your lordship, and then we subtract it from the actual consumption of the meter for the preceding 12-month period. So that gives us the probable unauthorized consumption on the basis of which is billed.
Oh, my lord, they have mentioned it at page 54 in the bottom. If your lordship will find, my lord, because December, my lord, it is highest, my lord. December 13. Then 14, my lord, this is so and so.
So you have to add up the 12 months and divide by 12 or the whole or the 1 year's bill you have to.
1 year's bill we have.
They have got to pay.
Yes. Because that is the mandate of section 126.
That, my lord, that your lordship see. My lord, it is fluctuating, my lord. Here, January, February, less, my lord, January to May. Then again, it is increased, my lord.
But what does 126 say?
126 says, your lordship,
126.5 says, my lord, that
126.
the entire period during which unauthorized use of electricity is taken place.
And if, however, the period during which such unauthorized use of electricity has taken place cannot be ascertained, such period shall be limited to a period of 12 months immediately preceding the date of inspection.
My lord, this from June onward, it is more, my lord. Lesser, my lord, is May onward.
After he has indulged in theft of electricity, installing a foreign circuit, what is more, because there is a formula given under the act. It is not his case that the formula has been wrongly applied. The formula which is given.
What is his case?
What I have perhaps understood now is that he is saying that firstly, the appellate authority has not rendered a finding that he has indulged in unauthorized use of electricity, which he has. But instead of using the term unauthorized use of electricity, the appellate authority has used the term malpractice. So the description of the acts which the appellant has indulged in, that would be covered within the ambit of section 126, which amounts to unauthorized use of electricity. The second argument which was raised, perhaps, your lordship, is that since he has installed a foreign circuit, so that would be covered under section 135 amounting to theft of electricity and not under section 126. Perhaps that is another argument from the written submissions which have been submitted. So that issue is no longer res integra, your lordship, because the coordinate bench and the division bench of this High Court has already held that even if a person indulges in theft of electricity, to determine the loss, your lordship, of that he has caused to the licensee, that amount is to be assessed as per the procedure laid down under section 126. So that issue has been covered here. That issue is no longer res integra. And thirdly, your lordship is raising some factual issues, that whether that meter is changed, how he tampered with. So once the appellate authority has rendered its finding on fact, your lordship. So this is a proceeding under section 226, your lordship. So perhaps if the appellate authority had the option of giving a finding either way, two views are possible, then perhaps your lordship perhaps may not like to, your lordship.
What about his initial, in his note, he has given that facts of the case?
Yes, your lordship.
That there was an inspection report made.
Yes, sir.
Where it was found that the meter was intact.
Yes, your lordship. What I'll just give your lordship the brief facts of what has happened. On 17/12, your lordship, and in
Wait, I think just call 5 minutes. Just 5 minutes. Okay.
out of the premises of the petition. During the inspection, your lordship, inspection report, your lordship will find a page number 35. This inspection was in the presence of the consumer's representative. This is of 17/12/2014. The general remarks at the bottom of the page, your lordship. Meter cabinet found in seal condition bearing seal number so and so. The cabinet glass was found in, this is important, the word sick is there. In the original, it is found in broken condition. The original, your lordship will find that page number 37. It is there, your lordship. It is not there in the typed copy. In the original, it is there. The cabinet glass was also found in broken condition. At page 37, the original is there. So the cabinet glass was found to be broken.
Yeah.
No trace of burnt marks at the CTPT and other accessories, example so and so, so and so. Photographs have been taken for further examination and evidence. As per verbal discussion with the CEO JEC, the metering cabinet with the remain of the burn meter perused inside is hereby seized in sealed condition in presence of consumer and APDCL officials for ascertaining the cause of damage at TNC Lab, Jorhat. However, the consumer is instructed to provide for undertaking, stating their willingness to pay the cost of new meters, ETPD set, and 10 core cable at the earliest. So his meter was found to be burnt, your lordship. The glass was broken. the meter was seized for further examination at the TNC office. That examination, Your Lordship, took place finally on 27th of March 2015, Your Lordship, that Your Lordship will find at page number 39. This was in the presence of the consumer's representative. What the officers of APDCL determined was, it is concluded that the reason behind the burning cannot be due to any electrical fault, as a 110 volt 5 ampere fault flowing via CTPD set can in no way raise a short circuit current of such magnitude so as to burn a high tension meter. Therefore, the reason behind the burning is due to some external impact and not due to internal electrical short circuit. However, the consumer denied any wrongdoing, so the meter is to be sent for forensic testing and analysis. The entire cabinet is hereby resealed, bearing seal number so and so and seal number so and so in the presence of the consumer. After that, what happened? We send it to the forensic laboratory. But later to the state for forensic laboratory. We have stated so in affidavit, Your Lordship, that the forensic laboratory refused to conduct an analysis because there was no judicial order backing such request. So they sent the meter back to us. Thereafter, Your Lordship, a decision was taken to test the meter at the premises of the APDCL itself. So we sent a notice to the consumer asking him to be present for such inspection because that is the mandate of the supply code also, that he has to be present. So he responds to such notice, Your Lordship, on 21/2016. The reply is at page number 40. What he says is, the last paragraph at the bottom, you are requested to fix some another date convenient to you on some Saturday as our advocate so-and-so has gone out of India and would return on or about 21/1/16. But before fixing another date, you are requested to apprise us about the provision of law which empowers you to undertake fresh further physical verification over the meter in respect of concluded verification of meter and to supply us a copy of forensic report of testing and analysis, if any, conducted over the meter. You are further requested to supply a copy of CD containing the video recording of meter of physical verification dated 27/3/2015. To this, Your Lordship will respond, Your Lordship, on 25/1/2016, saying that we had only seized the meter, Your Lordship. The actual cause of the fire was yet to be ascertained. And the forensic laboratory had stated so in affidavit, they refused to conduct a test. So be that as it may, Your Lordship, a test is conducted, to which, Your Lordship, instead of, because they did not put their signature on the verification test, but they submit a representation wherein they have admitted that they were present during. So it was not that it is not their case that they were not present during the verification. What they have stated in their objection to the verification submitted on 29/1/2016, which is at page number 35, because this is the first verification, because the forensic laboratory has refused. At page number 36, the last paragraph, they have stated, anyway, under the threat of disconnection, we are compelled to appear today for the so-called fresh physical verification testing of seized removed meter. As such, we have every reason to believe that as during the long period of the last 10 months, the meter was lying in your possession and custody, you might have done something to the meter so that we may be penalized by involving in some sort of malpractice, which was not found during the physical verification dated 27/5/2015. But in your letter, which is issued in stereotype style, you have wrongly mentioned the date of the said verification as 6/6/2015. In the premises, we are lodging our written protest and objection on the course adopted by you and reserve our right to seek legal protection from the appropriate court of law, both civil and criminal. Thereafter, Your Lordship, a notice was issued to him as per section 126. This is the provisional assessment, along with the statement which Your Lordship will find at page number 45. This notice specifically says, because a case was made out that they were not informed that they had indulged in unauthorized use of electricity, this notice specifically says, dear Sir, Madam, evidence revealed that you were directly or indirectly involved in the act of malpractice as defined in clause 4.5.4 and 5.8.3.2 of the ARC Electricity Supply Code and Related Matters Regulations 2004, read with section 50 of the Electricity Act. A statement showing your involvement is being enclosed here, which has Annexure 1. If you remove the unauthorized portion of so and so, you are requested to appear in the office of the JESD one APDCL during the working hours on 1/2016 for collection of provisional assessment bill assessed as per provision of clause 5.8.4 of the AERC Supply Code Regulations 2004 for compensation of the loss of to the utility due to you committing malpractice. So to this, they make another representation.
No, why are we going through all this?
Yes, because your lordship, finally everything has merged in the order of the appellate authority. They have gone to the appellate authority under section 127. So if your lordship has the order of the appellate authority, which is the impugned order, which starts at page number 60, because these grounds were made out, that was why I was responding.
No, you see, now the issue is, these are questions of fact.
These are questions of fact, your lordship.
Can the writ court go into it?
In fact, in some similar cases, your lordship, relying on the judgment of the Honorable Supreme Court in Suryadev Rai and Swaran Singh, coordinate benches of the coordinate benches and the division bench as well, your lordship, they declined to examine matters of fact, your lordship, particularly in when orders are passed under section 127, because your lordship is not exercising appellate jurisdiction over the order of the appellate authority, because this is extraordinary jurisdiction under 226. The parameters of challenge would be, or judicial review would be somewhat different, your lordship. So if your lordship pleases, may I place those judgments there?
Okay, so just once more. The points raised by the petitioner are threefold, correct?
Yes, your lord.
One is that what are the 3 points?
Firstly, from what I've understood is that since a foreign circuit was involved, found inside the meter, that would amount to theft of electricity under 135. So the procedure under section 126 cannot be resorted to. Learned senior counsel will correct me if I'm wrong. So that issue is no longer res integra because in the judgment of Shivaloy Steel, this is APDCL, and confirmed by the division bench as well, that it has been stated that
Procedure under 125.
126. So the procedure under 126 can be applied even in cases of theft of electricity under 135.
According to him, it cannot be applied.
According to him, it cannot be applied. That is one of the grounds made out in the petition.
And it has to be under section 135.
135. Because that would be that is the procedure laid down for theft of electricity. The second and primary ground, your lord.
Yes.
The second, primary ground on which the petition is structured, your lordship, is that due to the delay in testing, perhaps what has been projected is perhaps the officers of APDCL must have done something. So therefore, he cannot be blamed for any foreign circuit being found inside the meter. And the third
Yes.
And the third ground, your lordship, which has been made out is from the written arguments, is that the appellate authority has come to a finding that even though the meters, the seals were intact, though because there were hinges present on one side of the meter, the hinges can be tempered with to install a foreign circuit inside the meter. He's saying that that finding the appellate authority, that is finding could not, the appellate authority could not have arrived at. The fourth, your lordship, ground is that instead of using the formula under clause 5.8.4.
Hinges were open. Oh, what? Damage.
So I'll just explain, your lordship. So the meter door, your lordship, it has hinges on one side and the other side it can be open. To prevent opening, on the other side, seals are present. The seals are found to be intact. But what the appellate authority held was that since there are hinges on the other side, the hinges can be removed, the foreign circuit can be installed, and the hinges can then be reinstalled, your lord. So those are the four grounds, your lord.
What is the fourth ground?
This is the fourth ground.
No, there's a third and fourth. Appellate authority could not have come to a finding.
Yes, the fourth ground, your lordship, is that the formula under clause 5.8.4.4 of the supply code.
Formula under
5.8.4.4. 5.8.4.4 Lordship will say chapter 5 otherwise because the formula is the same formula. That formula should not have been applied. And instead, his average consumption for the previous 12 months should be taken into account to determine the amount of compensation that he has to pay. So, regarding the first issue, Your Lordship, I'll just issue because regarding the first issue on whether cases involving theft of electricity are covered under section 126, that has been already decided by the coordinate bench, Your Lordship. That judgment is there. Paragraph number 22 of this judgment, Your Lordship.
Yes.
In view of the said discussion, I am of the considered opinion that the provisional assessment by the assessing officer against the act of indulging in unauthorized use of electricity after an inspection of any place or premises of a consumer and the final order of assessment of the electricity charges payable by such consumer under section 126 is not restricted only to unauthorized use of electricity simpliciter, but includes such unauthorized use of electricity where there is an allegation of theft of electricity defined under section 135 of the Act of 2003. And accordingly, issue number A, that is whether provisional assessment by the assessing officer against the act of indulging in unauthorized use of electricity after inspection of any place or premises of a consumer and the final order of assessment of the electricity charges payable by such consumer under section 126 is restricted only to such unauthorized use of electricity where there is no allegation of theft of electricity defined under section 135 of the Act of 2003 is decided in the negative. So that issue is been decided, Your Lordship. So because since there is no separate formula given under 135 to determine the electricity charges payable, the procedure under 126 has to be resorted to. So in fact, against that order, he has already filed an appeal under 127 also. Now, second, Your Lordship, he said that the formula under clause, I'll just address the issues in order of priority. The formula under clause 5.8, chapter 5 should not be applied, Your Lord. But Your Lordship, that formula, the supply code is not under challenge. And once the period for which the unauthorized use of electricity cannot be ascertained, then the formula under chapter 5 has to be applied. Then thirdly, Your Lordship,
Yes.
his contention is that we could not have done a second inspection, second verification. So my first response to that is it is not a second verification because the first verification, there was no conclusion. It was decided in the presence of a representative of the consumer that the matter would be sent for forensic analysis. Since the forensic laboratory refused to do it, Your Lordship, we conducted an analysis at our laboratory.
So it's a first examination according
It's
to.
the first examination, and there is no bar under the Act, Your Lordship. Because to make up his mind, this way or the other, the assessing officer has to conclusively determine whether unauthorized use of electricity or theft of electricity has taken place. Now, we found a burnt meter, and according to the assessing officer, he could not determine how that meter was burnt because according to his understanding, the voltage that would ordinarily pass through the meter would not result in a fire of that magnitude. So, upon opening, Your Lordship, opening the meter, the findings of the second verification is enclosed as a part of the appellate authority's order. A foreign circuit was found installed. He is saying that since the meter was in the custody of the APDCL all along, we must have perhaps installed the foreign circuit and he is not responsible for it. But the important thing to note, Your Lordship, is that he was present in the first verification also. And
First verification.
the first day when we decided to send it for forensic analysis, he was present then. It was sealed in his presence. And on the second day also, he was there. Though he refused to put his signature in protest, but he was present. He has said that you have compelled us to be present, but he did not put his signature. Now, on the basis of the report, the appellate authority has arrived at the finding of fact that yes, there was a foreign circuit found installed inside the meter. And since the meter has hinges on one side and the glass was found to be broken, it is possible that the consumer may have removed the hinges, installed the foreign circuit, and then refixed the hinges. So that is his understanding of the factual situation. And on that basis, he has affirmed the order of the order under section 126. So that is a pure finding of fact, Your Lordship. It might be that the petitioner can very well project a fact that yes, the appellate authority could have arrived at a finding that since the seals were found to be intact, then how can a foreign circuit be placed? But once he has arrived at the finding of fact, Your Lordship, this is one possible explanation for this event, then perhaps his view, I do not find any informative in his view, Your Lordship. So for that, I would be relying upon a judgment of the coordinate bench. Firstly, on the judgment of the Honorable Apex Court in Suryadev Rai, Your Lordship. And relying on that, the coordinate bench had passed the judgment. Firstly, in the judgment of Suryadev Rai versus Ramchandra Rai,
Yes.
Your Lordship, I'll just clarify, part of this judgment was overruled later in Radhesham. This is regarding exercise of supervisory jurisdiction over the civil appellate courts that Your Lordship is aware. But the rest of the judgment has remained untouched, Your Lordship, particularly
Regarding challenge to judgment passed by a civil court.
civil court. That was overruled in Radhesham, but the distinction between certiorari and supervisory jurisdiction,
So that is not the issue here.
that the distinction is the issue here. The other issue is, other thing is not an issue here. The other part. I'll take Your Lordship to the conclusion at paragraph number 38 of Suryadev Rai, page number 694. Para 38, Your Lordship, the conclusions are there. The relevant subparas would be 3, 5, 6, and 8. Subpara 3 says, Your Lordship, certiorari under Article 226 of the Constitution is issued for correcting gross errors of jurisdiction. That is when a subordinate court is found to have acted, 1, without jurisdiction by assuming jurisdiction where there exists none, or 2, in excess of its jurisdiction by overstepping or crossing the limits of jurisdiction, or 3, acting in flagrant disregard of law or the rules of procedure, or acting in violation of the principles of natural justice where there is no procedure specified, and thereby occasioning the failure of justice. Subpara 5 says, be it a result of certiorari or the exercise of supervisory jurisdiction, none is available to correct mere errors of fact or of law unless the following requirements are satisfied. That is, the error is manifest and apparent on the face of the proceedings, such as when it is based on pure ignorance or utter disregard of the provisions of law, and 2, a grave injustice or gross failure of justice is occasioned thereby. And number 6, a patent error is an error which is self-evident. That is, when can be perceived or demonstrated without involving into any lengthy or complicated argument or a long-drawn process of.
I think we have to review.
Regarding exercise of jurisdiction under 26 also, where 2 inferences are reasonably possible and the subordinate court has chosen to take one view, the error cannot be called gross or patent. Then number 8, Your Lordship, the High Court in exercise of certiorari or supervisory jurisdiction will not convert itself into a court of appeal and indulge in reappreciation or evaluation of evidence or correct errors in drawing inferences or correct errors of mere formal or technical character. Now, relying on this judgment, a coordinate bench, Your Lordship, in the case of Parvati Tea Company, the other judgment, I'll just read out the relevant portion, paragraph number 15. There also an order of the appellate authority was under challenge. It is settled that an appeal, more particularly a statutory appeal in its continuation, is continuation of the original proceeding, and the power of the appellate authority as regards appreciation of facts is coextensive with that of the original authority. Insofar as determination of question of facts are concerned, the appellate authority is the final arbiter of facts. It is also a settled principle of law that certiorari jurisdiction can be exercised only for correcting errors of jurisdiction committed by inferior courts or tribunals. A writ of certiorari can be issued only in the exercise of supervisory jurisdiction, which is different from appellate jurisdiction. The court exercising supervisory jurisdiction under Article 26 of the Constitution of India is not entitled to act as an appellate court, and as such, there is clear limitation in the findings of fact reached by the inferior court or tribunal as a result of the appreciation of evidence cannot be reopened or questioned in its proceedings. It is only an error of fact which is apparent on the face of the record which can be corrected by a writ of certiorari, and not an error of fact, however grave it may appear to be. Reiterating the same principle, the Honorable Supreme Court of India in Suryadev Rai Supra has entirely observed to the effect that certiorari under Article 26 of the Constitution is issued for correcting gross errors of jurisdiction. A writ of certiorari is not available to correct mere errors of fact or of law unless the following requirements are satisfied. That is, the error is manifest and apparent on the face of the proceeding, such as when it is based on clear ignorance or utter disregard of the provisions of law, and 2, a grave injustice or gross failure of justice occasioned thereby. Where two inferences are reasonably possible and a subordinate court has chosen to take in one view, the error cannot be called gross or taping. It has been observed that the High Court in exercise of certiorari or supervisory jurisdiction will not convert itself into a court of appeal and indulge in reappreciation or evaluation of evidence or correct errors in drawing inferences or correct errors of mere formal or technical character. So after that, Your Lordship, two separate judgments of the coordinate bench and the division bench are referred to. But on the same grounds, another challenge to an order of the appellate authority, Your Lordship, was dismissed. So my contention is, Your Lordship, that from the grounds made out in the petition, Your Lordship, no cause for challenge has been, no cause for interference with the order of the appellate authority has been made out. Once he has been found to have tampered with the meter, once the appellate authority has arrived at a finding, then the procedure under section 126 and the formula laid down in the supply code will apply. And even otherwise, Your Lordship, that formula is not under challenge in this. That is
my main count, first I have said, my lord, the meter was found to be in seal condition. Seal was broken, there was a plastic cover. Then, my lord, my question is this, my lord, how in a seal condition, any external circuit can be put, my lord? Well, they have justified it saying that there's a hinge. My lord, this is in the door, my lord, the hinge is there, my lord, the kabja. If kabja is open, my lord, can it be put it again, my lord, there? My lord, this is error, my lord, this is the error manifest on the meter was found to be totally sealed, my lord. All sides, my lord. They say the hinge is open. Can be hinge be again put? My lord, that is the main question, my lord. How one of the external circuit can be put inside the meter? The seal meter, my lord. That report is very clear, my lord, that meter was found in total seal. This is my first question, my lord. This is absolutely, my lord, this error is manifest, my lord, from the, my lord,
What is the finding? That
yes. My lord, the appellate authority order is there.
page 61, page 61,
findings are at 62.
60,
62.
2.
The meter was not burned due to internal electrical short circuit, as there was no trace of sparking crossover mark in the current path. Protection system provided.
No, come to the next one.
Hello?
The next, number 2.
Yes. The appellant indulged in the malpractice. Foreign circuit was found inside the meter, which proved that malpractice was in the premise of the appellant. The seal of the meter was found to be intact, but it does not imply that the meter cabinet box cannot be opened for tempering the meter. Well, this is the answer. As one side of the cabinet box cover is hinged, giving opportunity to open the meter. Well, how can that is my.
You were there during the opening.
Well, that is why I wanted to put my comment. That did not allow me to put comment. That is why I have challenged that. I have immediately.
No, was there a foreign circuit inside?
No, not foreign, my lord. They have totally dismantled it, my lord, in the ground. the meter. That is why I wanted to, my lord, put my comment there in the inspection report. They did not allow me. That is, my lord, what my submission is this, my lord. Even the meter which is found to seal, my lord, totally sealed. One side, my lord, the kabja is opened, my lord, and to seal against kabja can be put, my lord. See, so this is fully, my lord, without, my lord, it is impossible, my lord. Thank you.
Where have you said that in your writ petition?
Yes. My lord, para 9, my lord, page 8. The petitioner stated thereafter in the name of first physical verification on 29 on the seal affixed of the meter cabinet was broken. The meter was totally dismantled. Video cover taken to show that to have access inside the meter, authority itself cut, broke the various seals and wires and removed the plastic tape and thereafter prepared a false minute for the petitioner who asked to sign the statement. The petitioner wanted to record his comment observation of on the minute of the signing and asked the respondent authority to let it do so. But the authority did not allow the petitioner to record his comment observation. The petitioner refused to sign the minute and write so and so. Email, letter so and so, same immediately. Inform the concerned official authority about the reason for the refusal signed to the physical verification report. By the aforesaid mail, the petitioner made it clear that further observations made by the authority over the minute, the same were made not only to make out a false case of malpractice against the the petitioner also informed that opening of the meter, it was not possible for the authority to either test the meter in automatic test bench or to examine the same in temper analysis field as due to burning of the meter on account of some internal effect. In fact, all the internal accessories has been melted and intermingled. In fact, the authority has taken law into their own hand, undertaking test visible in spite of the fact that on 27/3/15, decision was taken to refer the meter to forensic test analysis. But it was
Where have you said, where is the averment
Yeah.
that there was no foreign circuit found inside the meter?
well, that is what I am saying. Well, they prepared the report only.
No, but in your writ petition, have you said it? That's what I'm asking you.
Yes. The false report, my lord, that is what I am saying.
No, false report doesn't, false report can mean anything.
false
False
report, my lord.
report can mean that you did not find a packet of sweets inside the meter also. That's why I asked you specifically,
My lord.
is it your stand that there was no foreign meter, foreign circuit
My lord,
in the thing?
your lordship, see, my lord, cabinet box was broken and meter was totally dismantled.
Maybe.
Video program is taken to show the inside the
But
meter.
that is why when I ask you a question, you just have to answer.
Now, I am
Is it
coming, my lord.
correct? Yeah.
That is why, my lord, melted, my lord. That entire thing is melted, my lord. That is what I have said. All internal accessories had melted and intermingled. My lord, this is what I am saying. What is the question of my lord? All internal accessories were melted and intermingled.
In our affidavit, we have said so. Yeah, this. Point. We have said that it is stated at paragraph number 11.
That we have
It is
replied.
stated herein that a foreign circuit was installed inside the meter for pilferage of electricity designs.
Very good. My lord. That we have replied to one. My lord, para 12 of my reply. At page 6, my lord. The last 5 sentences. With regard to a statement made to affect the foreign circuit was installed inside the meter for pilferage to electricity reasonably, the answering opponent begs to specifically deny that the said so-called foreign circuit was there, and it is reiterated that defendant of prisoner who was present at the time of second physical refused to affix his signature on the physical report, as the respondent did not permit him to record his comments, observation in the same intimated question. So we have really denied, madam. Well, my humble submission only, my lord, the first question is this, my lord, that name. Fully, my lord, the meter, which is totally sealed, my lord, nobody can enter inside that, my lord. Unless, my lord, the seal is broken. And once hinge is broken, my lord, hinge is open, that never can be put it again, my lord. And secondly, my lord, another that I have said, that bill prepared, my lord, that itself shows, my lord, that how they have said it. They have given the reading, earlier reading. Two main argument is on two bases. My lord,
Further, the petitioner stated his apprehension that as the fees meter had been lying with the respondent authorities for 10 months, there was a possibility that the respondents had tampered with the meter so as to penalize the petitioner for some malpractice, which was not found during the physical verification dated 27/3/15. What is this 27/3/15? What is this date?
After the meter, after
Was
the
this
first
the-
inspection on 17/12/14, the meter was taken away. A physical verification was sought to be conducted, which your lordship will find at page number 39. There, the officer was the area manager, assessing officer. He came to he had a suspicion that because of the voltage involved, the fire of that magnitude could not have happened in the meter without tampering. So on that day, first decision was taken to send it for forensic
Okay,
analysis.
so it was not sent.
It was sent, but they refused.
Okay. Good stuff. Next para. Subsequent to the above facts, the competent authority in the APDCL submitted a provisional assessment bill dated 1/2/2016. Where is that? How much is the amount?
37 lakh, 39,000.
Right. Requiring the petitioner to pay rupees 37,39,764.
In addition to my lord, virtually the earlier, the amount will be 7,68,241 only. My lord.
Huh?
This entire amount of the yearly amount, it will be 7,68,000.
Plus 37 plus this amount.
Yes, no, 7, they deducted, yes, this amount and plus that amount. That amount already paid, so they have reduced that amount.
No, this is for 37 lakhs.
37 lakh, but they have reduced the already paid amount.
It says amount payable 37,36,764
Because 1 lakh,
only.
1,31,000 meter reading has been deducted, madam, already. That is,
After deduction, but this, how do we know that? This does not say.
clause C, madam.
Loss.
45,000, 4 lakh
49 was, okay.
minus this much. That's it.
But why minus?
That amount.
That's
is
already
paid-
been paid. You've already been paid.
paid, madam. That is all.
37,39,764, which is based on the total units billed upon the petitioner for the previous 1 year minus the amount paid for the consumed units amounting to rupees, consumed units of 13, 12, 38. Thereafter, the authorities in thereafter the APDCL submitted final assessment bill dated 28/5/2016. Where is that?
58.
Huh?
58.
58. Whereby it held that the provisional assessment bill amounting to rupees 37,39,760 was to be considered as the final assessment bill. Next part. The petitioner thereafter filed the appeal petition via appeal number 02/2017 before the appellate authority of the APDCL under section 127 of the Electricity Act 2003. Next paragraph. The learned appellate authority thereafter came to a finding that the meter was not burned due to any internal electrical short circuit. And that the main cause of the burning of the meter could either be an external impact or injection of external fire to the meter through the broken window of the sealed meter cabinet inside the premises of the consumer, comma, for which the consumer was solely responsible as per clause 4.2.1.2.5. Huh. Should I mention it again? 4.2.1.2.5 of the Electricity Supply Code and Related Matters Regulations, 2004, bracket First Amendment 2007, hereinafter referred to as the First Amendment. Page 62. The appellate authority also came to a finding that the appellant indulged in malpractice in view of the fact that a foreign circuit was found in the meter. The appellate authority also came to a finding that though the seal of the meter cabinet was found intact, comma, the one side of the cabinet box cover was hinged, HINGED, comma, giving ample opportunity to open the door of the meter cabinet for tampering with the meter. Further, in view of non-cooperation of the petitioner, there was the cooperation of the petitioner and causing delay. Caused the delay in finalization of the assessment bill within the prescribed time limit. The appeal was accordingly rejected. Next paragraph. The petitioner's counsel submits that when the seal of the meter box was found intact at the time of seizure of the meter box, comma, the respondents could not now take the stand that a foreign circuit could have been inserted inside the meter box. Further, the meter box was in the custody of the respondents for more than 10 months, for around 10 months, which gave them ample time to
They have used the phrase, do something with the meter.
Okay.
to tinker with the meter box system. Tell that it is That is the main thing.
That is the main, my lord. Second, my lord, that they have not find out, my lord, that there was any short, my lord, unauthorized use of electricity, my lord.
Hmm?
They have not find out that any unauthorized use of electricity.
He further submits that in terms of section 126 bracket 5 of the Electricity Act 2003, if the assessing officer reaches the conclusion that unauthorized use of electricity has taken place, comma, then what happens?
My lord, that forwarding letter is at page 50, my lord. That,
So they've given you the provisional list.
my lord, a provisional bill along with that letter 50, my lord.
So what is wrong?
Nowhere, my lord, they have stated, my lord. Oh, I'm sorry, well. Yes. Page 54, provisional bill.
Uh,
That letter is at page 50.
Hmm?
Letter is at page 50. Here, my lord, they have not said, my lord, that, my lord. They only quoted the regulation. They have not come to the conclusion that the unfair use of electricity was there.
no, they said that you are directly or indirectly involved. They have said this. They have taken, they have followed it.
Malpractice, they say.
Huh?
They say malpractice, but my lord, average, my lord, they does not come to the conclusion that, my lord, for this period, my lord, unfair use of electricity was there.
Acha, okay, what have I said? Comma, the consumer has to be informed of the period when the unauthorized use of electricity took place. However, the same is not reflected in the letter dated 1/2/2016 issued by the area manager IRCA, APDCL, Jorhat, to the petition. He further submits that the procedure under section 126 of the Electricity Act cannot be applied with respect to theft of electricity. And it has to be under section 135. Full stop. Next paragraph, the learned counsel for the petitioner further submits that you said that this formula, the code cannot be applied. Chapter 5, why?
One of the grounds made out in the petition.
Chapter 5 of the code cannot be applied. You said that?
Oh, my lord, I.
No, no, you not said that. You cut that. Yes. Next paragraph. Mr. K.P. Pathak, the learned counsel for the APDCL, on the other hand, submits that in terms of the judgment of the coordinate bench of this court in the case of Shiv Alloy Steel versus Assam Power Distribution Company Limited and others. 2021 4 GLP GLR 558. An allegation of theft of electricity can be decided under section 125, is it? One,
What is
One
justice
twenty-
says that even in cases of allegation of theft of electricity, the procedure under section 126 can be used
applied.
to determine the electricity charges payable by such consumer.
What have I said? An allegation of, in cases of allegation of theft of electricity, comma, the charges payable by the consumer can be decided even under section 126 of the Electricity Act. What's that? He has also submitted, he also submits that in terms of the judgment of this court in MS Parvati Tea Company, huh? Okay, WPC 6343, Act 2012. And no, that's it. The court exercising supervisory jurisdiction under Article 2 to 6 of the Constitution of India is not entitled to act as an appellate authority. And as such, comma, there is clear limitation in that the findings of fact reached by the inferior court or tribunal as a result of appreciation of evidence cannot be reopened or questioned in writ proceedings. Full stop. He has also relied upon the judgment of the Supreme Court in the case of Surya Dev Rai versus Ramchandra Rai and others, 2003, 6 SCC 675, which is to the effect that they take this down in this same order. Huh? Page para 15, okay. 15, 1-5. Okay. I'll put this. I'll write 15 of it. Okay. Then you write, on considering the submission made by the counsel for the parties, this court is of the view that the petitioner should produce the respondent should produce the verification report, physical verification report made on 29/1/2016. with regard to examining the meter on the said day. On the next date, huh? List the matter on
12th of November.
huh? And the this bench is why in a hurry? This one is what? The 2017 matter.
Very well, as per your lordship.
No, when you were it. 26.
Maybe the week after that.
Too far, I think, 26. No.
No, 21st, I am in some difficulty. Right. Very well.
When?
Very.
List the matter on
Thank you.
19.
Or should we keep it as part of then?
Should I?
Then it'll be at the top of the list. So since you
Huh?
otherwise.
I don't like to keep things part of it is like a Damocles sword over the head. I put everything there.
Yes, your lord.
Most of the things are there.
Yes.
Huh?
Everything has been eaten, madam.
If your lordship keeps it as part of then will be before your
That's
lordship,
already,
then
Huh?
perhaps it will be.
Okay, list the so as part of. Put this in the. What is this matter? Labor court matter.
Award has been challenged by both the side, the management as well as the workman. Lordship, this matter will take some time because I have to go through evidence and all. May not
So
be finished.
for item number 19 is the writ petition filed by the workman
Ah,
against the award, and 20 is the writ petition
Management.
by the management, only agreed by a portion of the award where the direction for payment of compensation was given. After holding everything to be right, but it went hayward. Is a case where the petitioner, the workman was retired on attaining the age of superannuation. Now, the workman's claim is that he was wrongly retired, the date of birth was not correct, and in support, in the labor court, without first filing any application before the management to rectify the date of birth, he produces a certificate, and that certificate was also not accepted. And the labor court, after holding, yes, management was justified to retire the person on the basis of the recorded date of birth. However, then he should be given a compensation of 1 lakh.
Why?
That is the reason why we have a challenge.
Held that no domestic inquiry has held.
Yes.
That is the reason.
Huh?
The reason
Domestic-
given is no domestic inquiry is held. My lord is aware that domestic inquiry is held only when there is an allegation of misconduct and that person is given an opportunity where the inquiry is held and the charges are established. So my lord, in a case where a person is retired on attaining the age of superannuation, no domestic inquiry is required.
So what is his case?
His case is that it was wrongly recorded.
No, his case is that he has been wrongly retired. It was not
Because
his
the date of birth recorded by the management.
So he's still he's challenging the date of birth.
Yes. He wants the date of birth was wrongly recorded and in.
At the time of making his engagement card or whatever.
Yes.
Nothing was produced.
No, the PF, he admitted that in his PF form, his date of birth, he has put his signature. He admits that it is my signature. It was that
Provident fund.
Provident fund.
That is after retirement.
No,
At the time of retirement, just
No,
few
no,
days before that, that
no,
is
no,
the
no.
finding, Lordship.
no. The PF form was given long time back. It is his case that after he gets the notice of retirement, or at least 2 months before his date of retirement, he procures a school certificate. And there also, my lord, the name of the workman, his father name is not matching. So it requires some hearing if your lordship is ready. Then
I'm depends upon you. If you are ready, I'm ready.
If you want, I'll take at least 20 to half an hour.
How long will you take?
definitely, my lord, some time.
He'll need another half an hour.
Can it be taken about 29th, my lord? We don't.
29th?
Yes.
29th is a Friday.
No, 29th.
Acha, this-
Tuesday, Lordship.
You mean next week? No, no.
Fifth.
5th and 7th of, we are chock-a-block full.
Lordship had fixed one matter up on 12th, in my, is a labor matter on 12th.
We have fixed a lot of matters actually. Some matters, the problem is if we fix matters and sometimes it is the all who take a adjournment. And when you take the adjournment, then it's okay. But then if you all don't take, then I've got a whole bunch of lawyers waiting for their turn. So it becomes very taxing for us also.
Agree.
Because now you have to go make correction, write the proper, get the judgments. So we can fix a date, but not so early. The issue doesn't seem to be very complicated.
Yes,
It shouldn't take so long, I think.
yes.
I think
Only
15
thing, my
minutes,
lord,
15,
will-
in half an hour we can complete this.
19 or 21, Lordship?
21, sorry, 19, it can be done. 19th of November.
We are trying. This is the matter on 19th of November on the prayer of the classes for the parties.